My lord, item number 1. My lord, kindly see this order, my lord. It's a my IG application number 278 of 2025. In this matter, my lord, order has been passed. I never mentioned this matter, my lord. This application, this GA 278, this file my lord, in connection with the GA 251 of 2022.
Oh, GA 278 of 2025.
Yes.
Okay.
Yes.
This matter,
This
what
my
taken-
application.
it's your application.
Yes. Unfortunately, this mistakenly
Cost title is the same.
cost is same.
So what was this? What is this application for?
My application for intervention of the application GA 251 of 2024.
Anyway, so it will be taken up along with the other applications.
Yes, my lord.
Yes, it will. There are other applications
Other
fixed on
application fixed
this
first.
September. It will be taken up along with
Yes,
those.
my lord. Kindly place on that day my application.
No.
Because this is mistake, my lord. The advocate on record name not probably in the list, my lord.
I'm keeping it on that day.
My lord,
Yes.
kindly one thing, my lord, kindly allow me to intervene the application for GA.
Anyway, it will be taken up in presence of other side. You will be heard on that day. Yes, record an order.
আমি ইন্টারভিউ করছি মানে সাবসিকুয়েন্ট পারচেজ আর
কি নাম?
বাসারাত আর
কেউ আসেনি নাকি? আচ্ছা, আমি অর্ডারটা করে দিচ্ছি তাহলে।
আপনি তো 2 নম্বরে বসেন তো।
আচ্ছা, আইটেম নাম্বার 1।
আপনার নামটা কি? আমি একটুখানি হয়ে যাবো অর্ডারটা নিতে দিয়ে দিচ্ছি আমি। আছে
You are representing?
I am representing on behalf of the GA number 25825 intervener.
Okay. No, this today GA 278 is appearing.
278 is my application. This is mistakenly, my lord, it was recorded 271 of 2020. Is actually my I think it is actually GA 258 of 2022.
278 is appearing. So this application is yours.
Yes, my lord. There was my lord landed advocate on record. My lord name was the mistake. SK Ghosh. My landed advocate Tapos Kumar Das.
You are representing whom?
The course hearer. Blood the lawsuit, he mentioned that GA number 251 appearing on this application lawsuit. This application is fixed on the 1st September lawsuit.
এইটাই ধরুন তারপর থেকে of the sharers are present. ঠিক আছে? Let this matter appear on 1st September 2025.
Kindly correct this order sheet name, cost title GA number 278 in place of my lord 238. There was a mistake.
No, I am keeping this matter 278 on 1st of September. It will be taken up on that day.
Advocate on record name is SK Ghosh. My advocate on record not SK Ghosh. That Tapos Kumar Das. That was mistake, my lord, on that day.
You see, in order dated 6th of August 2025,
Yes.
appearance recorded is Mr. Tapos Kumar Sinha, advocate.
Yes.
And Shubir Sabut for the joint petition.
Yes.
And
Joint receiver.
Joint petitioner. Anyway, then Mr. Borito Sinha, Mr. Arindamuna,
yes.
These are all there.
Yes, yes.
So anyway, it will appear on 1st September.
In that manner, kindly see order GA 238 of 2022.
Okay. Let the order dated 6th August 2025 be rectified. Instead of GA 238 of 2022 appearing in the second paragraph, let it be GA 278 of 2025. Other contents of the order dated 6th August 2025 remain unaltered.
Well, copy of the 278 and 225, I have served copy of this by landed advocate. Kindly record it. Well, kindly recorded, I have served this copy. It's here and now.
You see, no, this 238 is wrongly recorded. It should be GA 278. As the copy has already been served, affidavits be filed in the meantime.
Yes. I'm deeply obliged. Well, my name is clearly recorded.
No, you give your name, it will be.
I have sir,
Yes,
নামটা দিয়ে
yes.
দিয়েছেন? নামটা দিয়ে দিয়েছেন? I'm grateful.
Item number 2, my lord. My lord, I'm for the defendant and applicant, my lord. My lord, in the order sheet dated
So
8
GA
August
GA 51 is
2025, my
whose
lord.
application?
Yes, my lord, my application, my lord. My lord, perhaps, my lord, in the third line of the said order, my lord, it would be 1 EI instead of 2 EI, my lord.
The appearance is
Okay, that means in the first paragraph and second paragraph, both.
Yes, my,
Okay, in second paragraph.
my lord is correct. The
Okay,
third line.
instead
is
of 2
application.
EI, it should be 1 EI.
Yes, my lord. Yes, my lord.
Yes, record an order. Learned advocate for the applicant, defendant number 1, capital E, stroke I, is present. Learned advocate
I'm
submit.
for plaintiff 4B, my lord.
And learned advocate for plaintiff 4B are present. It is submitted by the learned advocate for the applicant, defendant number 1 EI, that in order dated 8th August 2025, in the second paragraph, it is by mistake recorded as defendant number 2, capital E, stroke I, instead of 1, capital E,
Yes. Yes.
I. Stop. Let the mistakes be rectified. Other contents of the order dated 8th August 2025 remain unaltered.
Get one, my lord.
Lordship, number 3 and 4, Lordship, we have filed an Lordship, I'm for the defendant, but before the item number 3 and 4 is taken up,
So it is one application was disposed. Now today a date has to be fixed.
Lordship. But before that, at the cost of being repudiated, Lordship, I was opted to mention a matter. Tomorrow it is fixed.
Which
Tomorrow,
case? Which matter?
the matter has been fixed tomorrow by. No matter. It's a different matter.
So it will be taken up tomorrow. You mentioned tomorrow.
Pradeep Datta, senior advocate, has some personal difficulty, and that is the reason tomorrow I am mentioning up a
It's better you
notice.
mention tomorrow at the first sitting.
Tomorrow
of
at the first
yes,
sitting,
sub
and
notice
again-
is mentioned at the first sitting.
Lordship.
May I have your lordship's indulgence to mention that I was a bit late in coming, my lord.
So mention tomorrow. What is the difficulty?
Nothing, my lord. I am praying for a withdrawal of an application, my lord.
Very well, very well. Mention tomorrow.
As of this matter, I am for the plaintiff.
So in this item number 3 and 4, lordship, we have filed an intervening application.
Yes.
GA 15 and GA 11. Lordship, we have
GA
filed
15.
an intervening application.
Item 3.
Lordship, we have not been served anything.
Item 3.
Lordship,
Yeah.
no, copy has been lordship, it will be served.
No,
lordship.
item
It was
3,
sent
GA
to
15 is
5th
whose
of-
application?
This is my application, lordship. I am for the intervener.
Applicant.
Lordship.
So if this application is to be heard out, you have to serve the parties.
The copy has been sent on 11th August. Lordship, I think it has not yet reached.
For whom my learned friend is
He has been
I have disclosed that.
Heresy
I have
of
disclosed that in my application.
appearing and
No, no,
then
please tell.
I'm telling.
Please,
none of the parties are
Lordship,
Have
I
you-
am,
accepting him.
Do you have the affidavit of service?
yes, Lordship, I have, but Lordship, the postal track is not there. Only the postal.
Okay,
receipt
then I'm
showing
keeping it
is
after what, 2 weeks? Okay.
2 weeks.
But today is fixed for some
Lordship,
performance.
He
is
does not
the
in-
party here.
No, I'm not the party.
No,
member.
I'm-
Has been
For
matter
hearing
is
of this application, I'm keeping it after 2 weeks.
The matter is, this matter is appearing.
Lordship,
Lord,
none
as
of
to
the
be
parties.
mentioned.
Yes. What he, I
It is
accept to what he is saying.
action. We are in witness action. Your
So
lord
date has to be fixed for
Yes,
examination of the
for-
witness.
to play to
Lordship.
for the information about our performance. I am for the
The
response.
document has been served.
Right,
And
right,
it-
right.
And-
But
I'm making it.
Now the
clear.
question is, on the last date, I have passed an order
Yes.
with regard to a
On
particular,
28th of July.
on particular issue, I have passed an order, and today is fixed for fixing a further date for the witness action.
My,
So I have to,
and to inform about my performance.
yes,
Whether I have disclosed
Yes, yes,
my
yes.
document.
that you have
is
to,
be-
that you have,
I have already done.
okay.
And my learned friend for the petitioner, the propounder of the will, has also inspected my original
So
document.
later date be fixed for the witness action.
My,
Learned advocates for the parties are present. In terms of earlier order dated 28th July,
28th of July.
28th July
2025.
2025. Necessary compliance has been made by the learned advocates with regard to the documents sought to be relied upon.
And also inspected.
Necessary steps have been taken. Necessary compliance have been made, I have recorded. Let this matter appear on 1/9/2025.
My lord, difficulties is this, my lord. The witness is a senior citizen, lady staying in some other distant state. And another difficulty is
I think
getting
flights are there, so
for
I don't think
booking-
how there's a difficulty.
No, the ticket, the booking and the reservation is the problem.
He has to travel by.
He has to travel by train
Okay.
for his financial.
Anyway, you see, reservation can be made also in, anyway, 8/9/2025.
89. If
2025.
it is some other day, my lord, another week, my lord.
Any day that is
Nine- nine- nine-
every day they can't be here.
Okay. 15/9, 15/9.
19th, my lord. If it is 9th.
I'm keeping it 15. Any difficulty?
15 difficult. My lord, the difficulty is we are very close to the vacation. Then.
15/9.
15 also there. If it is 19th, my lord,
Yeah, we are opposing. My lord, this will be very,
19
very
is a
close.
Friday. Friday appellate side matters are taken up.
but
So there is some difficulty.
in Calcutta, my lord, on 19th, on 15th.
Okay, keep it, kindly keep it any day.
11th. Let it be 11th.
11.
11/9/2000.
11, the same thing. 8 and 11, there is no difference.
So that week you will not be there from 15 to 19.
15 and 16.
15 and 16. Anyway, then 17.
15, 16 and 17. My lord, 17.
So 17 I can keep it.
17.
Okay.
Yes.
My lord, will you please to kindly make
Let
an
this
observation.
matter-
This will be peremptory. My lord. They should not come
Let
and take
this
a time.
matter
Why preempted?
appear on
Peremptory, they have a difficulty.
Section.
17/9.
Difficulty.
Default, how it can be taken as a preempted?
Let this matter appear on 17/9/2025
That itself,
for
senior
further,
citizen lady.
further witness action.
Don't bring them as a witness then. There's
Yes,
no
with
issue.
regard to your applications, you serve and mention.
Lordship, can it be kept on 26th, Lordship, the application?
Yes, mention, you mention after service,
Why? Who is he appearing
after
for?
service is over, you mention, it will be taken up.
Lordship, we are
My lord,
appearing
another difficulty in the order, my lord.
Very well, after the service is over, you mention the matter.
Very deeply obliged, my lord.
At
Now,
the-
would it be your lordship's pleasure, my lord, to fix a time in the matter because it's a witness action
79,
My lord,
79 at 2 p.m.
at 2 p.m. I'm very deeply obliged, my lord. Very deeply.
my lord, regarding the order passed on 28th of July,
Yes.
there are some typographical mistake in the name of the advocates and the appearance too. I think the different
You
slip
give
has
a-
been followed up by the court officers.
Okay,
Maybe.
you give a suggestion, on the next day it will be corrected.
Your lordship.
What
your
is to be corrected, you give a draft.
I have only the name. I have
Very
underlined
well,
with
what
my
should be the correct name, you give that.
I am giving it.
Yes.
Slipped.
Let
Actually, give
let
it.
the names of the advocate recorded in the order sheet dated 28th July 2025 be rectified as per the suggested draft given by the learned advocate.
Only the appearance portion.
Yes, yes, names.
Yes, only the names appearance.
I'm very deeply obliged, my lord.
I'm
Grateful,
deeply
your lordship. Deeply obliged.
এটা 28 তারিখের order. I'm deeply obliged.
Grateful, your lordship.
My lord, I appear for the defendant numbers 2A, 2B, and 4, my lord.
But
I
appear for the defendant number
Thank
3
you.
in this matter. Your lordship would take up the last order On the last occasion, I have indicated that I have been appointed as an executor in this matter, and my name should be substituted in place and instead of the deceased defendant number 1. Now we have taken out an application. We have placed the matter before the master for the summons. Now learned master has raised certain objections. One of the preliminary objection of the master is that since I am representing in my personal capacity as a defendant number 3, then how can I again represent myself as the executor of the deceased defendant number 1? Now we have tried to satisfy the master that I am representing two capacities. One as defendant number 3 in the personal capacity, another as a executor of the deceased defendant number 1 as executor in the representative capacity. So if my lord directs the masters to my lord issue the summons, my lord I can please.
Where is the defect pointed out?
Defect is nothing, is all oral. My advocate on record has 3 times went to the learned master for the summons to get the summons so that service can be effected upon the parties, because they would be standing to oppose me.
What is your application for?
My application treated first to record the death of the deceased defendant number 1. Second to represent me.
Just a
Since
minute.
I have been.
Just a minute.
Yes, ma'am.
My lord, this is the affidavit that I have affirmed. And my lord, this is the master summons that I have taken out. I am for the defendant number 3. Defendant number 1 has passed away. My lord, I had earlier made an application that I had withdrawn because there were defects. Because I had not sought for substitution, recording of the names, and my lord, I did not make a prayer for my lord written statement. Now I had made this affidavit. It has been affirmed. My lord will kindly see the prayers in the master summons. I go to master summons.
Mr. Just for 1 second, Mr. Mukherjee is leading me. I am assisting Mr. Mukherjee.
Yes, he couldn't see me properly.
kindly don't.
Number 49. So these are the prayers that I have sought. Kindly cease recording of the death of the deceased defendant number 1. My lord, substitution of the defendant number 3 in the place instead of defendant number 3. My lord, the plaintiffs be directed to, my lord, reaffirm and re-verify the plaint after the amendment is carried out. Department was directed to.
Anyway, liberty granted, leave granted to file this application.
I'm extremely grateful.
Really grateful. Really grateful.
Leave to endorse. And my lord may keep the suit after 2 weeks, my lord, so that in the meantime we can do the need.
Anyway, I'm granting you leave. You just mention it after the compliance.
Very well.
Great.
I'm grateful to my lord.
My lord, in any event, the suit was supposed to be taken up today only. My learned friends have sought for time for filing of this particular application for substitution. So, my lord, the suit is on board today.
Anyway,
so,
but the defect has to be cured.
Absolutely. Let the application be on board and the suit also be be on board on that particular day.
To be mentioned.
Anyway, you mention the application after service is over.
Very well, my lord. I'll do that.
Your lordship kindly records that they are attempting to file an application today.
No, whatever it is, you see, I have just granted you leave. Achha, record an order. What is your GA application
number? I have
okay.
Not
learned advocates for the parties are present. Learned advocates sought for leave to file necessary application for substitution. Such prayer is allowed. Necessary application may be filed. Liberty to mention.
My lord.
Grateful. Really grateful.
Grateful, my lord. Deeply obliged.
For orders, item number 6.
Yes, 4 p.m. it is.
New motions.
I'm for the association respondent number 10. I believe the plaintiff
today is the date. Report of the special officer.
My lord, item number 8, I am appearing for the petitioner, my lord. The special officer is yet to execute the deed of conveyance.
So
my lord had passed an order on the special officer to execute a deed of conveyance in respect of the suit property.
So anyway,
My lord,
today is the date fixed for report.
my lord, is for filing my lord has already passed a direction for executing the deed of conveyance.
Yes.
That is yet to be carried out. My lord, in such circumstances, I am humbly beseeching my lord, kindly this matter be kept after the vacation. Meanwhile, the special officer will carry out the deed of, will execute the deed of conveyance.
Okay. Record and order. Learned advocates for the plaintiff, the applicant.
For the
Advocate for the applicant is present. Today is fixed for report of the special officer regarding execution of the deed of conveyance. As the said deed could not be executed, the matter stands adjourned till 3/11/2025 for report of the
Obliged,
special
sir.
officer.
Obliged.
I appear on behalf of the plaintiff. I'm for the defendant number 2.
Lordship, I am appearing on behalf of the defendant number 1, Your Lordship. Defendant number 2 in item number 21, and I am appearing on behalf of the interveners in item numbers 9 to 13, Your Lordship.
No, item number 9, GA14 is whose application?
14, 15 are my application
For
injunction and to cut the long story short.
No, 14, 15. Yes, GA16.
GA16 is by the defendant number 2.
For
GA17 is not taken out any application.
GA16 is for what?
Sorry, defendant number 1, Your Lordship. Recording of an order.
Okay. GA17?
Lordship, GA17 is my application.
Oh?
Lordship, for injunction.
Okay, and GA18?
Lordship, GA18 is again my application, which is for an application for addition of party. I'm for the intervener in the 2001 suit, Your Lordship.
Okay.
Lordship,
GA18 is a GA18 your application for it.
GA17, Malad, it's not correct submission, Malad. 17 has been filed by the sons of defendant number 1, Malad. It is for addition of party. And
Sons of defendant number 1 for substitution.
no, my lord, for being added as parties, because they say that they are co-owners of the suit properties along with the defendant number 1.
So are the affidavits complete in
Yes,
GA17?
yes, Lordship. Yes, Your Lordship. Lordship, may I just make one submission?
God for the?
I am for the plaintiff.
Yes.
There are talks of
Lordship,
going on. We have
Let me see the last order, please.
Malad was pleased to pass an order on 23rd July 2025.
Let me see the last order.
In the, okay. Malad, may I hand over the order? Submission
Lordship, there are two suits between family members, Your Lordship. The 2001 suit is for partition and 2004 suit is by the plaintiff praying for cancellation of certain deeds.
Last occasion, the matter was adjourned because talks of settlements
Yes, Your Lordship. Lordship, talks of settlement are still going on.
So it's better, I send matter to mediation, you hold settlement
No,
of...
Lordship, may I just submit this, Your Lordship? Lordship, the defendant number 2 in the 2004 suit and the defendant number 1 in the 2001 suit has already sent an email, Your Lordship. Parties have agreed that they will have a sitting on 21st of August, where all the family members have been involved, Your Lordship. Lordship, there are many properties involved in the matter, several companies involved in the matter. Some time will be required to arrive at an amicable settlement.
About the meeting?
The problem is that they have only called a meeting of the family.
Very well. You see, in terms of the earlier order, there was a direction to intimate you also for the meeting.
Yes, well,
are you intimated?
Yes.
Very well. You attend the meeting on 21st.
No, there's a problem, my lord. I am an octogenarian lady.
Yes.
I stay out of the state, my lord.
Yes.
I stay in Punjab.
Yes. Let her be represented by a learned advocate.
Learned advocate and a son, my lord. That is all I want.
Very well. Very well.
Because the male is category and they say that it is only a meeting to be held between family members. It is not.
Very well. Very well. The parties who are unable to attend may send their learned advocate.
Advocate and the
yes.
the representative.
to mediation, I am sure my learned friend's client will not be in a state to travel and attend the mediation proceeding.
Lawyer will attend.
That is why I am saying, Your Lordship, before Your Lordship send it to the mediation, because if the lawyer is there is no point of it. The mediator would want to talk to the clients. That is what.
Anyway, I'm keeping it on 25. After 21st, I'll fix a date.
Correct. Your Lordship will give us some more time. If we are not able to come to a conclusion or settlement by that time, then Your Lordship will send us
Yes,
to mediation.
recorded.
25th is the date of the meeting, but not 21st, my lord.
Okay, 25th.
Kindly keeps it after
Learned advocates for the part. Yes.
Let there be no lawyers. The family members.
Let there be.
No, if I may, Your Lordship, submit.
Yes, yes.
This litigation is going on since 2001.
Yes.
Everyone is a senior citizen. Someone
Yes.
is 89, someone is 90. They would want to settle the entire disputes. This is what we are told. This is what the clients have also said. So they are saying there'll be a lot of things which will be said, which is absolute family issues. They don't want to discuss between others. So let it be one chance.
You see, if the parties are unable to come.
Lordship, the son is there. She has 2 sons.
The problem is
Let the
that
family members sit.
I am cornered.
Why outsiders?
Where I am cornered.
Lawyer is actually, strict says lawyer is actually not an outsider. Actually, it's in the communication between the lawyer and the client. You see, it's a privileged communication.
Lordship, the only thing is the senior citizens are involved. They were always warring factors. Today they're wanting to settle. One opportunity, Your Lordship. Let the family members sit down. If it fails, then Your Lordship will send us to mediation.
That is why, Your Lordship, I made the prayer that before Your Lordship sends it to mediation.
Learned advocates for learned.
If it is
Very well.
If
Very
it
well, you
doesn't
see,
agree, there's no settlement.
if your client's interest is not protected,
Then there's no settlement. There's no settlement.
You give necessary advice to your client's son so that he can
Lordship,
apprise the other members what is their desire, and thereafter whatever is the outcome, he will intimate you.
If they agree, Lordship, if they agree, then there is a settlement. If they don't agree,
Yes,
there is no
learned
settlement.
advocates for the parties are present. It is submitted by the learned advocate that talks of settlements are going on, and the date fixed for meeting with regard to the said issue is on 25th August 2025. Learned advocate for defendant number 2 submits that her client is residing abroad and will not. Okay, residing out of West Bengal and may not be able to attend the meeting. And she will not be able to attend the meeting in the facts and circumstances.
2 sons.
The date and times of the meeting be intimated to the learned advocates for the parties, and the defendant number 2, who is unable to attend the meeting, may send her son or daughter, may send a son to attend the said meeting. Fix.
Lordship, may I just make one submission?
Yes.
In respect of item number 21, I was appointed. It's showing on the board. It's being taken up together.
So this matter?
Yes.
Yes. Okay, just a minute. Yes. Let this matter appear on 3/9/2025.
This is for item numbers 9 to 13.
9 to?
This is a 2001 suit.
9 to 13. Yes.
9, 13.
21 also same matter.
No, that is a different suit, Your Lordship. There is a different set of representation here.
Okay, other advocates are appearing.
Other advocates are there. So I am appearing for 9 to.
Okay, let it be called on then.
It's showing on the board. That is why I'm not.
On the last occasion also, Your Lordship had taken up the matters together.
21, whom are you appearing for?
My lord, I appear for the plaintiff in item number 21, my lord.
Yes,
my lord. Arising out of one order 39 rule 2 application, my lord. My lord, if it may be taken up together with this, my lord, it would be
item number 21. Let this matter. I'm keeping it on the self-subject.
Not for either of the parties, Lord. I was the receiver appointed.
Anyway, I'm keeping it on that day.
But I'm just seeking for my discharge.
Just wait for some time. Let this matter appear on 3/9/2025.
joint fund mean
Joint fund ticket.
Grateful, Your Lordship.
Grateful.
Gratefully, Your Lordship.
Lordship, my interim order expires on the 26th.
Yes, interim. Okay, the interim order. Which matter? Interim order was granted.
9 to 13.
9 to 13. The interim order granted earlier stands extended for a period of 4 weeks or till further orders, whichever is earlier.
Grateful, Lordship.
Item number 17 and 18.
Seventeen and 18, I am appearing for the plaintiff in one of the matters and the defendant in the other. My lord, there is an application for substitution which has been pending. That
GA5.
is GA5.
Whose
and-
application?
My lord, it's my application. I'm led by my senior. He's not well this week, my lord. I'm praying for a not this week.
Okay, then
My lord,
GA
keeps it after the vacation, my lord.
no, just not this week.
So
17
my
and
lord will
18.
kindly keep it after the vacation because my lord, if my lord sees the previous orders on several occasions, there has been adjournment sought. The reason I'm saying, my lord,
This is a contested hearing.
it will be contested. It will be.
Anyway, I'm making it not this week. On the next week, you take instructions and appear.
My lord, kindly keeps it after the vacation, my lord.
Why?
We shall.
Simplicity substitution application. Why?
No,
after
it is not a simplicity substitution
Very
application.
well.
My lord, there are issues.
Hearing cannot be concluded. I'll keep it after vacation. I'm just making it not
The
this
reason
week.
being the hearing, perhaps, my lord, with the pressing matters and disposals, my lord, this will take time. That is why I was playing that if it is after the vacation, we can come fresh.
Anyway, I'm giving 2 weeks time. Achha,
Very well,
17, 18, order to record.
Much obliged, my lord.
On the prayer of the learned advocates, the matter stands adjourned till 26/8/2025.
No problem.
Item number 19.
Yes. Not today.
Item number 20.
Item number 20, Lordship, I'm appearing on behalf of the plaintiffs. This is my application for substitution. During the pendency of the suit, plaintiff 1B.
Item 20.
Item 20.
Yes. You are for the plaintiff.
For the plaintiffs, Your Lordship.
You are come for the, you are now representing the heirs of the deceased plaintiff.
I'm representing all of the plaintiffs.
Yes. Give me the application.
It appeared in item number 17 and 18. 17, 18, 19 are all connected. 3 matters, my lord. 3 applications.
17, 18, 19 এ ওই সেম অর্ডার করে দেবেন ওই একই ডেট।
Much obliged.
This GA29, your application.
Yes, Your Lordship. So during the pendency of the suit, plaintiff number 1B, 1F, and defendant number 5 have died interstate. So their legal heirs are now required to be substituted. That's why I filed this application.
1B?
The 1B, 1F, and defendant number 5.
1B, that is Sushanto De.
Yes.
1F.
Yes, yes, Your Lordship.
Okay, 1F.
1B, 1F, Reena De,
Yes.
and defendant number 5.
When did they die?
Just a minute, Your Lordship. Your Lordship, defendant number 5 died on 21st February, 21st May 2023. Plaintiff
May.
21st May. Plaintiff number 1F died on 29th December 2023. And plaintiff number 1B died on 18th of March 2025.
Yes. Which paragraph you have stated?
Your Lordship, it's starting from para 26. Page 20.
Para 26. Who are the substituted heirs of this defendant?
Your Lordship, it's mentioned therein.
Yes.
All the substitute heirs
Okay,
are mentioned.
26. Defendant number 4 died on 21/5/2023.
Your Lordship, it is actually an error. It should be defendant number 5. Later on, it's mentioned correctly in the next para.
Okay, 21/5/2023. And plaintiff number 4 died on 29/12/2023. that is plaintiff number 1F. So for defendant number 5 is concerned, that is 21/5/2023. Who is the other plaintiff?
The other plaintiff is in the next page, Your Lordship, para 29, plaintiff number 1B.
18/3/2025.
Sushanto De.
Where have you made the prayer? The years be substituted as per so and so paragraph. It should be there. Years has to be substituted in respect of a particular paragraph.
Your Lordship, I have annexed the proposed amended plaint in Annexure S.
Yes.
Hmm. Just a minute. It's in page 110. I've shown it over there.
No, what is this? What was this application for? GA 28/2023, Annexure R.
Your Lordship, it was also for substitution. Similar
Substituting
application.
which defendants?
Your Lordship, defendant number 1, 7, 8, 9A, 10, 11, 12, 14, 18A, and 20.
One, that is the original defendant.
Yes, they are the original defendants. 18A was not original, he was substituted. Hmm. Your Lordship, may I forward a copy of the previous application?
Yes. Yes, record an order. Learned advocate. for the applicant years. You are for, oh, you are
For the plaintiffs,
applicant
existing
years
plaintiffs.
of deceased plaintiff number
Deceased plaintiff. 1B, 1F,
1B,
and 1F.
1B and
1F.
1F is present. The application GA 29 of 2025 is taken up for consideration. The applicants in the said application has sought to record the date of plaintiff number 1B, 1F and the defendant number 5, as also with a prayer to substitute the applicants in place and state of defendant number, plaintiff number 1B and 1F. Upon perusing the petition and upon considering the facts stated therein, this court is of the view that the applicants have been able to furnish grounds for the delay. Thus, the delay should be condoned and this application should be allowed. Let there be an order in terms of prayer A, B, C, D, E, and F of the master summons dated 1st day of August 2025.
Your Lordship, one indulgence. I'm appearing on behalf of all the plaintiffs.
Yes. আচ্ছা তাহলে এটা করে দিন তো learned advocates
The existing plaintiffs.
for the plaintiffs is present. Applicant na diye?
Plaintiff number 1.
Anyway, for all the plaintiffs.
For all the plaintiffs. Much obliged, Your Lord.
This one, allowed.
Item number 22.
Please, Your Lordship. This is my petition. My lord, we have taken an exception to the report of a commissioner, my lord. That the pleadings are complete. This has a checkered history. I'll indicate quickly what the pointers are, but may I come back and argue this? My lord, this will take some time.
GA9.
GA9. But before I
Your
do that,
application.
It's my application, my lord. Because the report of the commissioner suffers from inherent, my lord, mistakes. And that inherent glaring mistake, I'm sure my learned friends cannot improve the facts. But kindly take a volume 2. I'll just indicate quickly and then I'll come back on another day, my lord. I'll argue this matter because this is a checkered history. It'll take some time because I have to go into the facts and then explain.
Is
My
it
lord,
not an auspicious day
It is
today?
not. It is not really.
Is it not an auspicious day today for you not to argue? I do not understand.
I'll quickly indicate page
So affidavits are
206.
complete in this
Yes,
matter.
yes, everything is complete.
Pleadings
but
are complete, my lord.
Because of this, my lord, challenge, we cannot execute, we cannot go ahead with this.
They can't go ahead because there's a suit which is prior in point in time, my lord, which we have filed. And those two, my lord, have to be heard together. There's a lot of facts. That's
If
the reason.
decree
When
has reached its finality, then that has to be executed.
Nothing. It is, my lord, pending adjudication. There is no finality, my lord. Here, it's a suit.
I'm short. Let my learned friends.
Anyway, you start the matter.
Absolutely. Absolutely. My lord, kindly take up page 206 of, I'll give the bird's eye view, my lord. Kindly take up page 206. We will, my lord, on a particular day.
Number of occasions now.
My lord, kindly take up page 206. I'll indicate how erroneous the report is. And this is the premise of the report. So I'll indicate, my lord, after this, really nothing remains in the matter. Volume 2. And I'll start with the report because, my lord, from there I'll show the perversity in the report. And I'll also indicate why I need to come back. I'll also indicate that, but not before I show this. Volume 2.
207.
Waiting, volume 2. Page 206, the report starts, my lord. I'll not trouble your lordship with anything. Kindly take up, my lord, page 206. शुरू है Milord, page 206 is that. Yes, Milord.
So this is the statement of accounts.
So this is the report of the commissioner.
No, 206 of the petition টা দিন।
এটা ভলিউম 2 GA9 এর দিন, GA9 এর ভলিউম 2 আপনি অপোজিশনে দিয়েছেন নিশ্চয়ই।
পিটিশনটা দিন।
পিটিশনেরও এরকম কপি 3টে ভলিউমে আছে পিটিশন।
এইটা হবে
না, এটা হবে না, এটা
না, এটা না।
তিনটে ভলিউম আছে 1 2 3
এরকম হবে।
না, we have not. আমরা একটা we had done it when affidavit also to begin with. It is the master summary. But in may I also indicate this what had happened, what had transpired? Yes, it.
GA9.
206, my lord. That's where the report of the commissioner starts. This is under challenge. And why I say a bird's eye view, my lord, is kindly take up page 211, my lord. I'll not trouble your lordship with anything today. Kindly take up 211. Paragraph 13, my lord.
Paragraph 13, yes.
While going through the statement of defense, and this is the premise of the report, my lord, I find that the defendant themselves have annexed a chart titled Outstanding Corporation Tax on Bharat Coking Coal, which is from page 141 to 146 of Statement of Defense. I pause here for a moment. This, my lord, is not a chart of the defense. It's a chart of the plaintiff. Kindly see, my lord, my petition once. And this is, my lord, absolutely erroneous. He has forgotten who has filed this. And he proceeds on a premise that this is a chart given by the defendant themselves. So he takes it as an admission of the defendant. But kindly take my petition once. I'll quickly indicate where we have stated this.
This page?
My lord, in our petition, page 9, subpara M, that's the second paragraph, my lord. Page 9, subpara M, my lord.
Yes.
Moreover, the report is based on an erroneous premise that a chart has been annexed in the statement of defense by the defendant and that the same tantamounts to an admission by the defendant without considering, my lord, kindly mark this, without considering that the said chart is a disclosure made by the plaintiff in an affidavit and not the defendant. The very premise being erroneous, the report is bad in law and should not be considered by the Honorable Court under any circumstances. This is my, the fact that the commissioner has made this mistake. Commissioner proceeds on a chart saying this is your admission. Forgets that this is not a chart by us, this is a chart by the plaintiffs. The entire report, my lord, is on this premise because the premise is that it's an admission by the defense. It's not an admission, it's their chart. He has lost that foresight, my lord, while passing this report. This is where I'll start from because I have to then go into the facts. There are two separate suits, my lord. One suit is, my lord, filed by them. Our suit is prior in point in time where, my lord, the dispute is where, my lord, it's essentially an eviction suit for them. And for us, my lord, it's a suit for declaration because by the operation of law, we've become owners of the premises.
Anyway, this is one of your contention.
One of the major contentions, my lord. This is the primary contention. Today, if this is not, my lord, answered by them, then this report cannot be sustained in my very respectful submission. The rest of the points, my lord, I'll indicate, kindly fix on any date. We'll come with a list of dates because without the list of dates, my lord, I'm a little, because it has a checkered history, it will take a lot of time. With that list of dates, my lord, it will not take us more than 20 minutes. I'll restrict myself to the pleadings in the application. The pleadings are complete. Otherwise, I'll only indicate the relevant page numbers.
Yes,
and I'll conclude, my lord.
My lord, kindly gives a short date, my lord.
Yes, my lord, kindly.
Mr. Bagh submits on GA9 of 2024.
Will be,
but
hopefully we'll all be benefited with a list of dates prepared by Mr.
Let
Bagh.
this
Only for the court.
matter
Then I will object.
appear on
Next week, my lord, any date, your lordship.
But we are really suffering, my lord. We want to rely on this report, my lord.
Okay, 25/8,
25/8, my lord, will come.
2025.
But I take it he is going to complete on that. Indeed. I will, my lord.
25/8. I'm giving you.
My lord, is it your lordship's pleasure, my lord, to fix a time? Any time
25
slot,
কি
my lord.
ফিক্স ম্যাটার আছে দেখুন তো দুটোর সময়।
Otherwise, my lord, Mr. Bagh is a very senior, busy counsel.
My learned seniors will
No,
so
no, no,
busy,
no.
will not get hold of my learned
We are
seniors.
always there.
That's the difficulty.
Mr.
I'm
Bagh,
always there.
difficult to get hold of. My lord, let us see. Let us fix a time.
Only for my learned senior, my lord.
Very well. So be it.
25 দুটোর থেকে কি ম্যাটার আছে? অ্যাডজন মোশন
আচ্ছা, আমি আছি।
কটা আছে? 25 তারিখে দুটোর সময়? না দুটোর সময় দুটো আছে? ওটা কি উইটনেস? Okay, I'm keeping it at 2 p.m. on 25/8.
My lord.
Very deeply obliged, my lord. The next matter, my lord, is where we are the plaintiffs. That's the next matter, my lord, item 23.
Yes, you are appearing 23. Okay, analogously.
Analogous, my lord.
Yes, both 22 and 23.
My lord, deeply obliged.
Item number 24.
I appear for the judgment. Oh, your lordship, I appear on behalf of the decree holder by your lordship's last order dated 24th of
I am the applicant.
2025.
Probably I have appointed some special officer to
Lordship,
submit a
to
report.
carry out, your lordship, they had fixed a date on 9th of August, but your lordship, because of the rally and the demonstrations, they could not take symbolic possession. So, your lordship, in view of that, let the special, let the time.
Extend the time to submit
Yes,
the report.
Yes, your lordship, kindly do.
Yes, record an order.
Lord, GA1, would your lordship be pleased to?
Yes, learned advocates for the parties are present in terms of the earlier order dated 24th July 2025. The report could not be made ready by the learned special officer. Let this matter appear on 28/8/2025. GA1 of 2025 be listed on the same date.
Date, your lordship.
GA1, okay. The order কেটে দিন. Let the interlocutory applications be taken up on the said date.
But I have also
Great,
made an application, but on behalf of the state, my lord, to be included as a party, that will also appear, my lord, in the.
Yes, give the slip, it will appear in the usual court.
Maybe be also favored with a copy.
My lord, execution copy though. Not even they
Your
have
app.
served me with any copy, my lord.
So, your lordship, he's not even the judgment
Anyway,
at.
you see, after you have filed it, you mention it will appear.
Very good.
Lordship, let them serve a copy upon us.
Definitely, if they don't serve,
Very well.
I will not take it up.
Grateful, lordship.
Lord, GA1, my lord, I am the intervener.
Yes, that is yet to be taken up
Yes.
on the next day.
Lord, on the next event, my lord, then kindly, my lord, allow me liberty today, my lord, to serve the state. Because my case is that the state.
Let copy of
Lordship, let the state be added as a party first. It's not a party to the application yet. Your lordship is.
My prayer is.
Okay. The application
Lordship, kindly.
GA1 of 2025
Yes.
may be served upon the intervening applicant.
Lordship kindly appreciates today neither my learned friend is a party to the proceeding nor the state is a party to the proceeding.
If they have something to say, state.
Lordship, let him first get added as a party.
No, I understand my friends.
Without getting added as a party, I am a decree holder from a suit. He is an intervener. He's not been added as a party. The state is also saying that they filed an application without being added as a party. Your lordship, they want service.
Let the copy be served.
Very well.
You know who the real decree holder is. My lord, upon the intervening EOW, he's not an applicant, my lord, he's the intervening EOW. My lord, the EOW.
Let him say for that.
My lord, my friend is representing.
My friend knows who's Mr.
Okay,
Sarkar representing.
It's better I delete regarding service of the copy. You first place your application thereafter.
Lordship, let them be added as a
No, my
party.
lord, kindly,
The
my lord,
collusion
kindly,
is apparent.
I shall hear both the application on the
Lordship,
next day.
kindly.
My lord, that may, my lord, perhaps delay my application. Your
No,
lordship may
GA1 of 2025 is your application.
Lordship,
That is your application. Okay, then you file it and not just mention.
Lordship,
You file it and then mention.
grateful, Lordship.
All suits, item number 25. Item number 25,
Yes, not today.
item number 27,
Yes, not today.
witness action, item number 29.
Item number 29, my lord, as for the plaintiff, my lord. But what happened in this matter, my lord, your lordship appoint a commissioner to take evidence of a defendant witness number 4.
Yes.
My lord, since then, my lord, defendant is not cooperating, my lord. Only one day, my lord, witness has taken. Thereafter, my lord, he is issuing a letter and issuing a doctor certificate that he is ill. He is ill means he is a back pain. That's why, my lord, commission has not been taken. My lord, your lordship kindly make it to not today. Let them come and your lordship my lord, complete the witness act. Witness of defendant number 4.
How many depositions you have taken?
No, only one.
Only one day.
Only one day. My lord, your lordship kindly see the letter, my lord. Kindly see the letter, my lord. What is letter they have written? And my lord, your lordship kindly see the doctor certificate. Doctor certificate, your lordship kindly see. Taken doctor certificate. Lordship kindly close the evidence. My lord, this is a suit of 1999. My lord, he is not cooperating. And one after another, my lord, he is taking adjournment. He has also paid, my lord, 10,000 rupees cost for taking adjournment. Once. Unnecessary, my lord, suit is getting delayed.
not
Yes, record an order. Learned advocate for the plaintiff
I'm for the plaintiff.
is present. Learned advocate commissioner is also present. It is submitted by the learned advocate.
This letter.
Yes, that the defendant DW1,
DW4,
that the DW3 is taking adjournment on frivolous ground, and the matter is being deferred for a long period. Learned commissioner submits a letter issued by the learned advocate for the defendant stating the illness of the state DW3. Upon perusal of the certificate issued by the doctor, it appears that DW3 is advised 3 weeks rest, 3 weeks rest on and from 2/8/2025. Stop.
Your lordship kindly see the reason.
Okay.
Acute back pain.
Okay, in the facts and circumstances, the defendant, the learned advocate commissioner shall take deposition on any date after 23/8/2025.
23/8, Lord.
3 weeks. 3 weeks time.
That is 3 weeks, Lord. He is here suffering.
Okay. After in the event DW3 does not, yes, if DW3 does not make himself available for the deposition before the commissioner after 23/8/2025, the evidence of the said witness will stand closed.
Second,
Let this matter appear on 2/9/2025.
Every time, Lord, this is happening from the beginning. Lord, he has submitted a doctor certificate.
Yes, you are for the defendant.
Yes.
You see, 3 weeks time the doctor has given. I have directed the commissioner to take the deposition after 3 weeks. But after 3 weeks, if he does not make himself available, the evidence has to be closed. You please take steps and advise your client accordingly.
Grateful, Lord.
Yes, take back. Yes, I've kept it on 2-9.
On frivolous ground, time is taking. He is not coming. He is saying he is a back pain. He can give evidence by sleeping. Not that he has not worked.
No, as because you see, there is a certificate. I have just kept it after 3 weeks. If after 3 weeks he does not make himself available, it will be closed.
Item number 32. Item number 32.
Yes, not today.
Item number 33.
Not today.
34.
Not today.
35.
Not today. ঠিক আছে আবার দুটোর থেকে আচ্ছা এই যে একটা ইয়ে আছে ওই কালকে একটা হিয়ারিং এ ছিল ওটা দেখি আজকে আবার নেই ওটা দেখুন কালকের লিস্টটা আছে কালকে হিয়ারিং এ বলতে কি ভার্সেস রায়গড় জুট মিল ভার্সেস স্টেট ব্যাংক হিয়ারিং এ ছিল কালকে হ্যাঁ তো পেপারটা আমার চেম্বারে আছে হ্যাঁ হ্যাঁ কালকে দিয়ে দিন তাহলে ফাইলটা আমি তাহলে পাঠিয়ে দিচ্ছি ফাইল আর বইটা পাঠিয়ে দিচ্ছি তাহলে ওটা যদি হয়ে যায় তাহলে ওটা ইয়ে হয়ে যাবে কি বলছেন ও তাহলে বাড়িতে আমি ইয়ে করে নেবো ঠিক আছে
My lord, may I be permitted to pray for one indulgence, my lord?
Yes.
My lord, that's just a restoration application. This I'm praying for the listing. This is just a restoration application.
Inclusion?
Inclusion.
Yes, give the slip.
Restoration. Take it over. Grateful, my lord.
Lord, 2 p.m. fixed matter. Fix for arguments, my lord.
Item number 15 fixed at 2 p.m.
My lord, I appear for the petitioner. My lord, the petitioner caveator, my lord.
Yes.
My lord, the plaintiff was making submissions. My lord, I already concluded. If, my lord, my learned senior friend concludes, my lord, will kindly allow me to come back on any day, my lord. I know my lord has 2 other fixed matters at 2 p.m. My lord, will kindly.
Your Lordship, the date when I will conclude and he has to conclude his arguments.
You have to submit.
Yes.
Thereafter, he will give the reply.
No problem.
Yes.
Other day may be fixed
Yes.
for his argument.
Oblige.
Lordship, in nutshell, Your Lordship, may I just indicate what has happened? And on the last occasion, Your Lordship, factually, Your Lordship, I was indicating, Your Lordship, certain broad aspects of the matter. Here, the Your Lordship, the testator is Bhagirath Murarka. And Your Lordship kindly remembers the fact, Bhagirath Murarka, Your Lordship, left behind a will. And Your Lordship, 2 people, Dr. Nirja Ratheria. Dr. Nirja Ratheria and Nisha Singhania, his own daughter, Your Lordship, they were appointed as an executor in connection with that particular will. Now, initially, when the two executrix filed an application for grant of probate of the will, at that point of time, the caveated Your Lordship has given a consent affidavit regarding Your Lordship, no objection in connection with the grant of the probate of the will. Does not matter, Your Lordship, when the citations
That
were
means
issued
the
to
caveated applicant.
Yes, Your Lordship.
Caveated present applicant.
Caveated is the present applicant before
Present
Your
applicant.
Lordship. Regarding Your Lordship, appointment of an administrator pendental item, alleging Your Lordship that there is a misadministration regarding the shares left by the main testator, Your Lordship, the Bhagirath Murarka. That is his case. Now, I was, Your Lordship, showing on that earlier occasion regarding the scope of the application, what is the scope of the application, and what are the various facts which has not been disclosed in the application itself. I was also, Your Lordship, pointed out that in general, Your Lordship, that's the section 247. The word may has been specifically, Your Lordship, inserted in section 247 of the Indian Succession Act. Only on that basis, it is a complete discretion of the Honorable Court that during the pendency of the probate proceedings, without removing the executors or after removing the executors, when an administrator pendental item is required to be appointed. Now, in this particular matter, I also indicated that in this application, what has not been disclosed, that's a pending civil suit before the Alipur court, wherein the applicant caveator has actually filed a suit claiming declaration regarding the shares which are admittedly was in the name of Bhagirath Murarka. Your Lordship, kindly take, Your Lordship, only to just refresh Your Lordship's last, Your Lordship, what submissions I have made. Your Lordship, kindly take the application first, because on that date, Your Lordship, I specifically mentioned that entirety has been suppressed only to abuse the process of the court and nothing else. Lordship, kindly take the application first. Paragraph 3 of that application
Yes.
Paragraph 3, Your Lordship, he has mentioned, Your Lordship, who are the legal heirs at the time of the death. The testator being Bhagirath Murarka died on, wrongly mentioned 13, it should be 5th September 2002, and is presently survived by the following heirs and legal representatives. That is Praveen Murarka and Nisha Singhania. Nisha, Your Lordship, is one of the executrix in the application for grant of probate, and this Praveen, Your Lordship, who is the applicant before Your Lordship. Now, paragraph 4, after the death of the testator, the plaintiffs being the executor of the will, dated such as 20th October 2001, filed an instant probate application being PLA 287 of 2007, praying for grant of probate of the said will in favor of the plaintiffs in respect of all the assets to have been allegedly left behind by Bhagirath Murarka, being the father of the defendant. Subsequently, on or about 16th December 2008, the petitioner herein received a special citation from the Honorable Court, thereby inter alia directing the defendant to appear in the said proceedings, being PLA number 287 of 2007. Thereafter, on 24th December 2008, the petitioner entered appearance by filing the affidavit in support of the caveat, thereby denying the case as made out by the plaintiffs in PLA number such and such. As a result, the state probate application became contentious in nature and was thus converted into a testamentary suit. Paragraph 6. The state probate application, now converted into a testamentary suit, discloses that the deceased Bhagirath Murarka was a Hindu governed by the Mitakshara School of Hindu Law, who died on 5th of September 2002, appointing the plaintiffs as the executors of the said will. It is pertinent to mention that late Bhagirath Murarka owned shares of considerable value both in his individual capacity as well as Bhagirath Murarka HUF, which we have disputed that there was no HUF at all, which is evident from the demat statement of Vedika Securities Private Limited, who is the broker and, your lordship, the depository participant. However, the said shares belonging to Bhagirath Murarka HUF was wrongfully included in the affidavit of assets as filed by the plaintiff in their probate application. The petitioner was thus compelled to raise his claim over the shares of Bhagirath Murarka HUF with a representation dated 27th of December 2004. The petitioner continued to raise objection to the same with no response from the side of the executors. What is important here, your lordship, kindly see the difference between paragraph 7 and 8. Their knowledge, they stopped from 2004. And from 2004 till 2023, your lordship, no explanation. Why? I'll show. That is, your lordship, will appear from my affidavit in opposition. Para 7 says till 2027 December 2004, your lordship, they were giving representation and raising objections. Now, at this juncture, upon receiving a letter on 16th of July 2023, the petitioner was shocked to learn. On 10th July 2023, the statement of holding of Shri Bhagirath Murarka shows only 3,000 DSQ software shares, equity shares in the account of the testator. All the other shares as shown in the demat account as on 5th of September 2002 were fraudulently transferred, sold or dispossessed in due course of the time to deprive the defendant, knowing fully well that some of the shares belong to Bhagirath Murarka HUF, and it is not permissible in law to transfer, sold or dispose of any assets without taking a probate of the purported will.
What is your stand in your affidavit?
Lordship, the stand, why I'm showing you, Lordship, 2004 and this particular letter, which is the cause of action, in the application, your Lordship, it shows that a letter came from the stockbroker and the depository participant that all the shares have been vanished. This is the case he has made out. All the shares have been vanished and only 5,000 shares. And this is a fit case where an administrative pendental IT, your Lordship, should be appointed. What has not been shown, that there was a civil suit filed before the Alipur court by the same plaintiff, or by the plaintiff who is the applicant before the Honorable Court. That person had knowledge, your Lordship, the entire facts in respect of the shares left by Bhagirath Murarka, and your Lordship, what has happened after the death of Bhagirath Murarka, how the nominee, his own wife, dealt with those particular shares. Your Lordship, everything has been disclosed, full-fledged trial has been completed, the suit is still pending for judgments. Now, suppressing the entire thing, your Lordship, from paragraph 7 to 8, he has come before this Honorable Court saying, kindly exercise your jurisdiction and appoint.
Have you dealt with it in your affidavit?
Entirety, your Lordship, on the last day I was showing that. Your Lordship, kindly take. Kindly take the affidavit in opposition. On the last occasion, I started with page 19. Then your Lordship pointed out, your Lordship, why this matrimonial suit, your Lordship, is as an item number 1. 19, your Lordship, is the list of litigations which this person, your Lordship, is doing against me my family members, his own sons, sisters, wife, father, against everyone, your lordship, he has filed, your lordship, all criminal cases.
And his relationship with the testator?
Son.
Son.
Son. Lordship, the son has already, your lordship, the given divorce to the wife. The wife, your lordship, was staying with the, your lordship, the father-in-law and the mother-in-law, along with his own sons, your lordship, with till your lordship, the death of Bhagirath Murarka and your lordship, Shashi Murarka. So, your lordship, the son has gone. But your lordship, the wife was there, the sons were there. Now, he started, your lordship, filing criminal cases against the father, against the mother, against the wife, against the two sons, against everybody, your lordship, he filed criminal cases but could not succeed. And all the relatives also, against Nisha Singhania also he has filed.
Anyway, you have dealt it with...
Yes, the most important factor, your lordship, which has been suppressed, kindly take paragraph page 20.
Yes.
Lordship, kindly take page 20. This is a suit, your lordship, filed by Bhagirath Murarka HUF, represented by Praveen Murarka. Your lordship, kindly see the cause title. Bhagirath Murarka HUF, represented by Shri Praveen Murarka as Karta and sole surviving members of HUF. Lordship, HUF, your lordship, the moment your lordship, the members, your lordship, dies, there is no HUF.
But there is a Karta usually.
There is a Karta, but your lordship, the Karta has to be a Hindu undivided family, bunch of people.
Yes. Karta,
he cannot be a sole person and being a Karta. Karta, your lordship, actually...
Yes, Hindu undivided family, Karta is there.
Yes, the main boss, your lordship,
Yes.
because the boss, you represent other co-partners.
Yes, yes. The senior member, one of the senior...
Senior member.
Yes.
Now, Bhagirath Murarka HUF, he represents himself as he is the Karta and sole surviving member of the HUF. There is no existence. That is the question before the Honorable Lalipur Court. Now, your lordship, kindly sees who are the parties here. Kindly take page 22. These two executors have been impleaded as parties. Defendant number. Unnecessary. Page 22, your honor, kindly, lordship, kindly.
Defendant number 4.
4 is Dr. Nija Rateria, who is one of the
Defendant number 5.
Defendant number 5 is Nisa.
Sister.
She is the sister of Pradeep. She is the sister of Praveen, who is the applicant and also the executrix in the will, along with Srimati Nirja Rateria. She is the relative. 4 and 5. And your lordship, kindly sees when the suit has been filed in the year 2008. Now, kindly take page 23. He has impleaded his two sons, Abhishek Murarka and Akshay Murarka, also as parties. Kindly see defendant number 6. Abhishek.
So in Mitakshara, when there is a survivorship of sons and everybody, grandsons, all come into the picture.
Yes. In Dayabhaga, once the father dies, then only,
then only they come into the picture.
Yes.
Mitakshara,
the moment
right from the birth.
Yes. The moment the person...
So they are from the Mitakshara.
They are from the Mitakshara school of Hindu law. Now, Abhishek Murarka, son of Praveen Murarka. These are the two sons who have been impleaded as parties. Now, kindly take page number 24. He has said suddenly in 2024, Vedika informed that only 3,000 shares of DSQ software was actually appearing in the demat account. Now, kindly see the defendant number 9 is impleaded defendant number 9 in the year 2008, completely suppressed. Now, what is this suit about? Kindly take the prayers in the suit at page 36. Lordship, kindly see, for a declaration that the shares and jewelleries described in Schedule A and Schedule B hereinafter respectively belong to Bhagirath Murarka HUF and Shri Praveen Murarka, being the sole surviving member of HUF, is entitled to all the shares. So this is his first prayer. The second one, for the further declaration that the transfer made by the defendants of Bhagirath Murarka HUF, more particularly described in Schedule A and Schedule B hereunder, are illegal and invalid. Apart from that, he has also asked for page 37 for accounts and also for an appointment of receiver to take possession of the shares and the jewelleries described in Schedule A and Schedule B of the property. No interlocutory application has been filed before the Alipur court for the appointment of a receiver. Now, Your Lordship, kindly take page 38. These are the list of the shares actually held in the name of Bhagirath Murarka. Page 38, Schedule A. Schedule A, the details of the shares investment at the cost price as on 31st of March 2002. So he has given the entire list of shares, and these are the shares which were the part of the affidavit of assets filed by myself, because Your Lordship, on the last occasion I also mentioned that being the executor of a will, I have to file an affidavit of assets along with the probate application.
Yes.
So as per the original side rules and the Indian Succession Act, it doesn't matter what has happened to the shares, I have to give the details of all the properties which was left by the testator at the time of death. So exactly I have done it. Now where the contention is, you have filed an affidavit of assets, mentioned these shares, but where the shares have gone? Shares in connection with these shares, you filed a suit, and now Your Honor, Lordship kindly sees the cause of action. Because he has said in 2023, his cause of action for appointment of administrative pendelite has come in the application. Your Lordship, kindly take page 35, paragraph 21.
Yes.
That the cause of action arose on 13th of October 2006 when Shri Paveen Murarka, the sole and surviving member of the said HUF, came to know the transaction of the shares of late Bhagirath Murarka and Shashi Murarka, who lived and died at 1/C Mandavilla Gardens, Kolkata 19, where the shares which are the subject matter of the suit were dealt with. And the learned court has both territorial and pecuniary jurisdiction to entertain the suit. So, in 2006, you had knowledge that, or rather, you had knowledge regarding the whatever the allegations you are making in this application, that in 2006, somebody was dealing with these particular shares. So from 2006 and now today in 2024, what prompted you to?
2006, this is the cause of action for filing the suit.
The reason is the
Now,
main.
what is the cause of action for this application?
Correct.
That is the
Lordship, kindly come to paragraph 8, page 4.
Yes,
Let's see whether the cause of action in the suit and cause of action in this application are completely identical or not. Paragraph 7 deals with the facts in connection with 27th of December 2004. Now, Lordship, kindly take paragraph 8. At this juncture, upon receiving on or about 16th July 2023, the petitioner was shocked to learn that on 10th of July 2023, the statement of holding of Bhagirath Murarka shows only 3,000 DSQ software equity shares in the account of the testator. All other shares as shown in the demat account as on 5th September 2002 were fraudulently transferred, sold or disposed of in the due course of the time to deprive the defendant, knowing fully well that some of the shares belong to Bhagirath Murarka HUF and it is not possible, permissible in law to transfer, sold or dispose of any assets without taking a probate of the purported will dated 20th of October 2001. A copy of the statement of the holdings of the testator issued by Vedika of the National Security Depository Limited as on 10th of July 2023 is annexed here too. Now, his contention is that in 2023, suddenly he came to know regarding this particular statement. What? That Bhagirath Murarka's demat accounts suddenly has been reduced and all the shares vanished, and only the shares of TSQ software securities is appearing. And that's why what he has done, he has approached this honorable court hurriedly. Now, Lordship, kindly sees paragraph 9. The defendant states that all the shares and other assets of the testator, which is the subject matter of the instant suit, have been transferred with full knowledge and consent of the plaintiffs to deprive the petitioner of his lawful claim of the shares of Bhagirath Murarka. Now, Lordship, kindly sees para 10. The deponent states that there would be a clear violation of law as well as the directions of the testator in the event the plaintiff being executor succeeds to fraudulently transfer, sell or dispose of further shares of the testator and distribute the same amongst themselves before the grant of the probate of the said will of the deceased. The deponent states that the plaintiff stroke executors have failed to take appropriate steps to protect and or act in terms of the estates of the deceased testator, even after being put to the knowledge of the above irregularities, and have thus failed to discharge their duties as the executors of the estate of the deceased in a fair and transparent manner. So therefore, the allegation is that shares actually in the name of the testator has been ciphered down, fraudulently transferred. Now, your Lordship, kindly equate with paragraph 21 of the affidavit of assets at page 35 of my affidavit in opposition.
Page 20?
Page, your Lordship, 35, paragraph 21 of the affidavit in opposition. The same allegations have been made in the year 2008 when the suit was filed, and saying that the cause of action arises in 2006. Your Lordship kindly sees that the cause of action arose on 13th of October 2006 when Shri Praveen Murarka, the sole and surviving members of the said HUF, came to know the transaction of the shares of late Bhagirath Murarka and Shashi Murarka, who lived and died at 1/C Mandavilla Garden, PS Gadiahat, Kolkata 19, where the shares which are the subject matter of the suit were dealt with, and the learned court has both territorial and pecuniary jurisdiction to entertain the suit. So you knew very well, and you filed the suit in the year 2008, but when you are coming before this honorable court, you suppress the entire facts and saying that suddenly in the year 2020-23, you have come to know what your Lordship, the depository has actually submitted. Now, what is important? Now, your Lordship, kindly take page 95, which is the subject matter of the instant application. Page
95 of the petition.
Of the petition.
Yes.
Now, your Lordship, kindly take page 95.
Yes.
Vedika is writing to whom? Vedika is writing to Praveen Murarka. And your Lordship also consider that Vedika is also a party in that suit. I will show your Lordship the written statement. Everything your Lordship has been given, your Lordship, in the written statement. Vedika Securities Private Limited is a defendant number 9 in the suit. Now, your Lordship, kindly take page 95. Dear sir, refer your letter dated 27th of June 2023. Not annexed. I don't know, your Lordship, what they have written, but they have taken this letter as the cause of action in this particular application for appointment of the administrator pendentility. With reference to the aforesaid letter submitted to investor cell of NSDL, please note that we haven't received any request and or letter regarding the requirement of the latest statement from your end. We have provided you the holding statement of Shri Bhagirath Murarka in the year 2018 based on the letter received from you from your end at that time. So therefore 2018, earlier they have given the statement. This is a subsequent one. As desired by you, we are enclosing the latest statement of the holding as on 10th of July 2023 of Shri Bhagirath Murarka. We are enclosing the ongoing matter as closed. So therefore 3 things comes up. First, he has not annexed with that particular letter dated 27th June 2023 what he has written. Second, statement has been given to them in the year 2018 during the pendency of the suit. Third, now they are again providing this particular statement as on 10th of July 2023. Your Lordship, kindly take page 96. This situation they were aware of at the time of the filing of the suit in the year 2018, but they have shown or given impression to this honorable court in the application that they had shocked to receive this particular statement. In this statement, your Lordship kindly sees DSQ software shares has been mentioned 3,000 as pledged shares. Column number just right hand side, just before balance. Value, rate date, rate, balance, pledge, 3,000 shares.
Page 96.
Page 96.
Yes.
There's a statement of Vedika Securities
Page
Private
is
Limited.
3,000 shares.
Yes. It shows, your Lordship, 3,000 DSQ shares are only left and there are no other shares in this particular statement. That is their cause of action.
Balance is also 3,000.
Yes.
The rate is 10,000.
Yes, Your Lordship, that's the valuation of the shares. Now, Your Lordship, on this basis, Your Lordship, they have approached this honorable court. You tell me the page number of the. Now, I have shown Your Lordship the paragraph 21 of the plaint. Now, Your Lordship, kindly take Your Lordship the plaint, and Your Lordship kindly sees paragraph 5 of the plaint at page 27. What is their allegation in that particular suit which is pending?
Yes, page 10.
No, Your Lordship, page 27, internal page 7 of the affidavit in opposition, page 27.
Yes.
Paragraph 5, that Dr. Nizar Atheria and Nisha Singhania, after illegally taking possession of the documents, assets and movable properties, including jewelries and cash, running into crores of rupees without obtaining any probate order of the purported will of late Bhagirath Murarka, of which they claim to be the executors, misappropriated, and they have not rendered into accounts of Sri Pravin Murarka, the Karta, and sole surviving members of the said HUF. In spite of the repeated demand, both verbal and in writing till date, it is needless to say that the two executors are guilty of criminal misappropriation and criminal breach of trust of all the movable assets of Bhagirath Murarka, individual and HUF, seized, possessed and removed by them in a car on 6th of September 2002, and the plaintiff reserves his right to initiate appropriate criminal proceedings against the defendant number 4 and 5. The letter dated such and such, written by Srimati Bhagirath Murarka to Shri Pravin Murarka, is a proof of high-handedness and criminal misappropriation of the two executors. Now, Your Lordship, kindly take paragraph 6. That Messrs Vedika Securities, the pro forma defendant number 9, had shares of late Bhagirath Murarka in his individual as well as HUF capacity under client ID number such and such, and late Bhagirath Murarka immediately before his death held all those shares in his name. A copy of the statement they have given dated 5th of September 2002. Now, kindly take page 28. Paragraph 7, he has given the history of the transfer of shares of Bhagirath Murarka is as follows. Para 7, that the history of the transfer of the shares of Bhagirath Murarka is as follows. The Bhagirath Murarka, including HUF, held those shares in DP client ID number such and such as on 12 September 2002 with the depository participant Messrs Vedika Securities Limited. The said shares were transferred to Shashi Murarka from Bhagirath Murarka in the same DP inner client ID number with DP Messrs Vedika Securities Private Limited in total disregard and violation of the Hindu Succession Act 1956. Pravin Murarka being 8 annas owner of the properties left by Bhagirath Murarka on his death. A transaction showing transaction of the shares from 1st of September 2002 to 22nd November 2002 being such and such of annexure V of the plaint. So he had knowledge in that the shares were transferred in the name of Shashi Murarka being a nominee. Now, the statement of holding of Shashi Murarka dated 30th of November 2002 with Vedika Securities Limited shows the transfer of the shares. So you knew very well at that particular point of time in 2002 that being the nominee, the shares were transferred. I was only trying to compare with this application. What prompted him to come before the Honorable Court for the appointment of an administrative pendant elite? Now, Your Lordship, kindly take page 29. That a large number of shares do not find any mention, and Shri Pravin Murarka has reasons to believe that they were misappropriated, and only some shares were transferred subsequently in the trust Bhagirath Shashi Murarka Foundation, as stated here in violation of Section 6 of the Indian Trust Act and the trustees without rendering accounts of those shares as provided under section 19 of the Trust Act and without obtaining any probate of the will of Bhagirath Murarka and Shashi Murarka have dealt with those shares for which they were bound to render accounts to Praveen Murarka being the only claimant of those shares forming part of the HUF. Now, Your Lordship, kindly take the details of all the shares they have mentioned. Now, I filed, Your Lordship, this is a lengthy suit, and Your Lordship, they had knowledge that where these particular shares were transferred in the name of Shashi Murarka. Now, what is important is the written statement filed by the defendant number 4, Your Lordship, who is Nisha Singhania, who is also an executrix in this particular probate proceedings. Now, Your Lordship, kindly take page 155, volume 2. And this particular written statement was filed sometime in the year 2013.
My lord, I'm sorry, I've taken permission from a senior friend.
Yes, your matter is happening for arguments.
Yes, fixed matter.
Yes, yes, it will be taken up.
Taken up.
Yes.
Just the matter after the argument.
Okay, after the, it will be taken up anyway. The fixed matters will all be taken up.
Page 155, Your Lordship, is the written statement. And Your Lordship, kindly take. No, page 155, Your Lordship, kindly sees.
Yes.
Page 55 is the written statement on behalf of defendant number 4 and 5.
One is the executrix, the other is the...
One is Nisha Singhania.
That is the executrix.
And one is Dr. Nija Ratheria. She's an eye specialist. And she's also a very family friend and relative, Your Lordship, of the family friend of the testator. So that's why the two ladies have been appointed as the executrix in this particular will. What I'm trying to show that in the year 2008, you had knowledge of entirety. In 2013, I filed the written statement. You had knowledge regarding everything. Full-fledged trial has been given. What actually prompted you to file this application suppressing the entirety? Now, Your Lordship, kindly take page 155, where the written statement of defendant number 4 and 5 is. Kindly sees page 179, the verification, and when I have filed this written statement before the Alipur court. Page 179, last, Lordship, kindly sees. 4th of June 2013.
Yes.
4th of June 2013, I filed this particular written statement. Now, Your Lordship, kindly see what are the important, Your Lordship, aspect of this particular written statement. Lordship, kindly take page 158.
Anyway, this is a part of your affidavit in opposition.
Yes, Your Lordship. This is a part of the
same stand you have taken, probably.
I have taken the same stand, and I have actually said, Your Lordship, what has happened. Your Lordship, after the death of Bhagirath Murarka, Shashi Murarka was a nominee. Now, Shashi Murarka, she was a grandmother of the two sons. She applied, Your Lordship, being a nominee, she applied before, Your Lordship, the Vedika Securities. And the shares were transferred being a nominee. Now, this particular man, Your Lordship, has separated with the family and has gone. Now, I have to see the future of my grandsons, his own sons. What I have done, the consideration amount, I have opened a trust.
What was the consideration amount?
The entire shares. Shares have been
How much?
transferred.
Valued at?
I will check, and Your Lordship, on the next day I'll indicate. Your Lordship, everything I've mentioned, and Your Lordship, the suit has been filed on that basis also, because trust is also a party in the suit. Defendant number 1, Your Lordship, is the trust. And Your Lordship, in all accounts, Your Lordship, we comply with the provisions of the Trust Act and we file it. Only the grandson's future, so that the grandson's future should be protected. Your Lordship, kindly take for page 158. On or about 27th of June 2000, the father of the plaintiff, Bhagirath Murarka, had applied to the defendant number 9 interiorly are requesting it to open an individual beneficiary owner's demat account with the said defendant. And I annex the copy of the application. The reason is I had shown that I have the Bhagirath Murarka specifically mentioned his wife as a nominee. Your Lordship, kindly take page 195 once. This is the application form.
Yes.
This is the application form with Vedika Securities Private Limited signed by
Page 195.
No, page 185.
Yes.
Page 185, Your Lordship, this is the application form signed by Bhagirath Murarka. Now, Your Lordship, kindly take page 188. This is the nomination form.
Yes.
Name and address of the nominee, Shashi Murarka,
That
who is my wife.
This is dated 2001.
Yes, Your Lordship.
And the will is executed
The will has been executed
in the year 2002.
No, in the will, date of the will. No, I am just giving the date. Sometime in 2001, Your Lordship.
20th October 2001.
20th October 2001, Your Lordship, the will has been executed.
Yes.
Sir, thank you. 20th October 2001, Your Lordship, the will has been executed. And this particular nomination, Your Lordship, is 7th of September 2001.
Okay.
Now, Your Lordship, kindly take page 158, paragraph B.
Yes.
Pursuant to such request and upon execution of a formal agreement on 27th of June 2000, the defendant number 9 duly opened an individual beneficiary's demat account in the name of Bhagirath Murarka, being client number such and such. Copy of the agreement is annexed as Annexure B. The said Bhagirath Murarka duly nominated his wife Shashi Murarka as his nominee in the said demat account, as would be evident from Annexure A and B here. The said Bhagirath Murarka was the sole and absolute and sole owner in his individual capacity of all the shares, debentures, etc. in the said demat account. Bhagirath Murarka died on 5th of September 2002, leaving behind him surviving Shashi Murarka wife, Praveen Murarka son, and Nisha Singhania daughter as his only legal heir. For a considerable period of time, running into several years, the relationship between Bhagirath Murarka and his sons, the plaintiff, were extremely strained. The plaintiff and the said Bhagirath Murarka, since deceased, were not on good terms and did not carry on business together. In fact, in or about year 1998, the plaintiff and the plaintiff and his father, the said Bhagirath Murarka, started living separately and also having separate mess and worship, and they had separated from each other, having their own independent lives and income. The plaintiff's mother, Shrimati Shashi Murarka, residing with her husband, that is the Bhagirath Murarka, for several years past, the relationship between the plaintiff and his only sister, the answering defendant number 5, had also extremely strained. The plaintiff and his wife, Srimati Sharmila Murarka, had also separated from each other and are living separately for long years. A decree of divorce between the plaintiff and Sharmila Murarka had already been granted by this court. The plaintiff's only sons, the defendant number 6 and 7, also live separately from their father, and the relationship between the plaintiff and the two sons, defendant number 6 and 7, is also strained. The plaintiff does not enjoy the good relationship with his with any members of his immediately family and or extended family. Prior to his death, the said Bhagirath Murarka had executed his last will and testament dated 20th October 2001. A copy is annexed. By the said will, the said Bhagirath Murarka appointed the answering defendants as the executrix in the said will, entitling the answering defendants to act jointly and severally. The answering defendants have duly applied for grant of probate of the said will, which is pending before the Honorable High Court at Calcutta, being PLA number such and such. Though the plaintiff had given his consent to the grant of probate of the said will, the plaintiff subsequently filed a caveat in PLA number 287 of 2007. In this connection, a copy of the affidavit of consent affirmed by the plaintiff on 19th of November 2004 is annexed and marked D. The said application for grant of the said will has been wrongfully contested by the plaintiff, and as such, the same has been converted into a suit which is pending. Now, Your Lordship kindly sees the affidavit, Your Lordship, of Praveen Murarka, which he has executed. That is also an annexure, Your Lordship, is in the probate application.
And you have annexed it here also.
I have annexed Your Lordship, with the written statement and, Your Lordship, the affidavit in opposition. (198). Lordship, kindly take page 197.
Yes, 197.
And this particular affidavit, Your Lordship, has been filed by Praveen Murarka in this probate application. Lordship, kindly take page 197. I, Praveen Murarka. Paragraph 2. The testator above named, who was a Hindu governed by Mitakshara School of Hindu Law, died on 5th of September 2002 at Woodlands Nursing Home, 8B, Alipur Road, in the town of Kolkata, after duly publishing his last will and testament in English language and character, dated 20th of October 2001, whereby he appointed Dr. Nirza Ratheria and Srimati Nisha Singhania, the petitioner herein, as the executrix of the will, entitling them to act jointly and severally. Dr. Nirja Ratheria and Srimati Nisha Singhania proposes to apply for grant of probate of the said will in their favor, and for this purpose they have prepared a petition which has been shown to me. Due execution of the said will would be proved by joint affidavit of the said Nirja Ratheria and Srimati Nisha Singhania, being the two attesting witnesses of the said will, as also by the declaration signed by the fourth. Now, he has given paragraph 6 the details of the heirs, and kindly sees paragraph 7. I have no objection whatsoever to the said Dr. Nirja Ratheria and Srimati Nisha Singhania being appointed as executors and trustees of the said will of the testators Bhagirath Murarka since deceased, and duly acting in terms of the said will and the probate thereof when granted. Kindly see the date when this particular affidavit has been affirmed, sometime in November 2004. And thereafter, suddenly he took a different stand and started contesting this probate application. Now, Your Lordship, kindly take
Hereafter,
page
the
160.
caveat was filed.
Caveat was filed. Affidavit in support of caveat has been filed.
Thereafter, it has become contentious.
Now, Lordship, kindly take page 160. Page 160. By the said will dated 20th of October 2001, paragraph G. By the said will dated 20th October 2001, the said Bhagirath Murarka since deceased bequeathed the valuable tenancy rights in respect of the office space at 7 Lions Range, as also the furnitures, fixtures, telephone, etc. lying in the said office in favor of the plaintiff. The said Bhagirath Murarka bequeathed all his properties and assets, including the bank balance, shares, and investment of his wife, the said Srimati Shashi Murarka, absolutely and forever. Upon the death of the said Bhagirath Murarka, his wife and the said Shashi Murarka issued a letter dated 10th of September 2002 to the defendant number 9, informing the death of the husband and requesting that all shares, debentures, etc. lying in the said demat account of Bhagirath Murarka be transferred in her favor. A copy of the letter dated 10th of September 2002 is annexed. Now, in that particular letter, Your Lordship, Shashi Murarka requested Vedika to transfer the shares in her name in her demat account, being the nominee. Your Lordship, kindly take page 201. Why I am saying so? Because they had knowledge regarding each and every facts in the year 2013 at least. Lordship, kindly take page 201. Page 201. This is a letter dated 10th of September 2002 from Shashi Murarka, who is no more right now. Mother to Vedika Securities Private Limited. And what is the request? I'm sorry to inform that my husband Bhagirath Murarka has expired on 5th of September 2002. He is holding the above mentioned account with you in which he has nominated me as his nominee. Hence, I request your good self to kindly transfer his holding into my demat account. Please find enclosed death certificate, notarized affidavit, and annexure O duly filled up as required for the process. The above given is your file. Kind consideration. Now, Your Lordship, kindly
So
take
whom did the testator bequeath this movable property, this
shares
yes.
in favor of the grandsons.
Okay.
Now, Your Lordship, kindly take page 160. Beneficiaries of the shares. Page 160. No, will. Page 160. Upon the death of Sri Bhagirath Murarka, his wife, the said Srimati Shashi Murarka, issued a letter dated 10th of September 2002 to the defendant number 9 informing the death of the husband and requesting that all shares, debentures, etc. lying in the said demat account of Bhagirath Murarka be transferred in her favor. Pursuant thereto, on or about 17th of September 2002 and 22nd November 2002, the defendant number 9 duly transferred the entirety of the shares except one share which was in a pledge account. And this is, Your Lordship, the DSQ software 3000 equity shares. So therefore, this cannot be a cause of action for filing of an appointment of administrator pendente lite. Lordship, kindly sees. Pursuant thereto, on or about 17th of September 2002 and 22nd November 2002, the defendant number 9 duly transferred the entirety of the shares except one share which was in a pledge account held by Bhagirath Murarka under client number such and such to the demat account of Srimati Shashi Murarka, being client number such and such, also with the defendant number 9. Particulars of the shares, debentures, etc. transferred to the said demat account of the said Bhagirath Murarka to the demat account of Srimati Shashi Murarka set out in a schedule annex and marked as annexure F. The plaintiff did not raise any objection to such transfer. So in 2013 at least, I have given the entire details where the shares of Bhagirath Murarka has been transferred in favor of Shashi Murarka being the nominee. So therefore, today you cannot come in and made a statement in paragraph 9 that you are shocked to know that.
No, was there any, in the plaint, was
Yes.
there any allegation regarding that transfer? Thereafter, you have filed the written statement.
Yes, Your Lordship.
Giving the total picture.
The allegation, Your Lordship, the allegation
was there.
Allegation was there. What I am saying.
Anyway, to that you have defended and you have clarified.
Moreover, in normal cases, Your Lordship, in under section 247 of the Indian Succession Act, courts, Your Lordship, unless and until there is a necessity, let's show the judgments of Calcutta and Bombay, Your Lordship, and the Honorable Supreme Court, that unless and until there is a necessity, usually the courts, Your Lordship, do not appoint administrative pendente lite and remove the executors. Because the executors are appointed by, Your Lordship, the testators or testatrix. And during the pendency of the probate application, as per section 211 of the Indian Succession Act, these executors basically, Your Lordship, represent the estate of the testators and testatrix. Now, today, why am I? What they have done, on the basis of, Your Lordship, the affidavit of assets, Your Lordship, they have filed a 340 against me also. That why I have mentioned in the affidavit of assets all these shares and the shares are not there. Lordship can understand.
340 is a separate issue.
340, Your Lordship, at the first initial stage, it should be dismissed, I'll show.
Whatever it is,
because the facts are same. Facts are, Your Lordship, same, Your Lordship, in the affidavit in opposition to 340 and affidavit in opposition for the.
You see, there is the scope is limited anyway, but this application has to be
Yes,
considered.
Your Lordship. Now, Your Lordship, kindly take page 161, paragraph J.
Yes.
Prior to the transfer of the said shares, debentures, etc. in her demat account, the said Shashi Murarka in her individual capacity held shares of various companies in her personal demat account, and particulars I have also given, Your Lordship, as Annexure G. On 9th March 2004, the Srimati Shashi Murarka created a trust by the name Bhagirath Shashi Murarka Foundation. The defendant number 2 and 3 were appointed as trustees of the said trust. At the request of Srimati Shashi Murarka, the defendant number 2 and 3 accepted to act as trustees within the confines of the said deed of trust dated 9th of March 2004. In terms of the trust deed, during the lifetime of Shashi Murarka, the trust fund was to be used for the benefit, her maintenance, her expenses for medical treatment, and household expenses as also for the education of the two grandsons. That is,
So this
the
is
defendant
this
number
was the
6 and 7.
intention of the testator.
Yes.
So whatever there as
Yes,
per
sir.
in the trust deed, that was the intention of the testator.
Intention of the testator, and
Whatever
thereafter,
it
your
is,
lordship, I have
the terms of the will
Yes.
also.
The trust further provided that upon the death, the defendant number 6 and 7 were to be the absolute beneficiaries of the trust fund. During her lifetime, the said Shashi Murarka purchased and sold shares of various companies. Out of the amount received by the said Shashi Murarka from the sale of the shares, substantial sums were utilized for her maintenance, upkeep, and medical expenses, and the balance sums were converted into fixed deposits and investment in mutual funds in her personal name. During the lifetime, the said Shashi Murarka also executed two gift deeds dated 30th June 2004 and 26th July 2004, whereby the said Shashi Murarka transferred a substantial portion of shares in favor of the trust, that is the defendant number 1 in this particular suit. Now, Lordship, kindly see subpara N. The said Shashi Murarka died on 11th May 2007, leaving behind her will dated 22nd of January 2005, whereby she appointed the defendant number 4 and 5 as executrix of the will, entitling them to act as jointly and severally. By the said will, the said Shashi Murarka, since deceased, did not make any bequest in favor of the plaintiffs. This is very important because today, your lordship, being I am the aunt of your lordship, the two grandsons, I have not got anything. By her will, the said Shashi Murarka, since deceased, did not make any bequest in favor of the plaintiffs, herein save and accept an idol of Lord Krishna. At the time of the death, the said Shashi Murarka was the absolute owner of some shares, particulars again I have given. After the death of Srimati Shashi Murarka, the shares belonging to the said trust, that is the defendant number 1, were duly transferred to his two beneficiary, its two beneficiary, namely the defendant number 6 and 7, being the grandsons and sons of the plaintiff, that is Pravin Murarka, in accordance with the provisions of the said trust deed. The answering defendants have not been bequeathed any movable and immovable or property by the said Bhagirath Murarka since deceased, and or by the said Shashi Murarka. The said Bhagirath Murarka had bequeathed his entire shareholdings to his wife, the said Shashi Murarka, who utilized a portion of the said shares for her maintenance, upkeep, medical expenses, and transferred the balance to the said trust for the benefit of the grandson. The said grandsons, the defendant number 6 and 7, have duly received the assets lying in the name of the trust. The plaintiff has been continuously, habitually, and repeatedly harassing the answering defendants, his sons, his wife, and the other family members. Several proceedings have been initiated by the plaintiff to harass and intimate the family members in an attempt to somehow illegally pressurize the defendant number 6 and 7 into parting with a portion of the shares, etc., received from the said trust. It is evident that the plaintiff is interested in denying and depriving his own sons from their lawful inheritance. The plaintiff has wrongfully and illegally sought to raise disputes regarding the transfer of the shares in favor of the mother, the said Srimati Shashi Murarka, for the first time on 17th of August 2006, and started making false and frivolous complaints against the defendants, and some of them with the defendant number 8. All such contrary complaints and allegations are false, frivolous, baseless, and absurd. In the present suit, the plaintiff has purported to challenge the transfer of the shares which took place when, even according to the plaintiff's own admission in the year 2002, in the premise, the suit filed by the plaintiff purporting to challenge the transfer of the shares and the purported claim of the plaintiff in relation thereto is hopelessly barred by law of limitation. These are the answers. What is very important here, the defendant number 9, the Vedika Securities, also filed a written statement. Page number 1. Lordship, kindly take page 239. Page 239 is the written statement filed by the defendant number 9. And this written statement has been filed by your lordship, the Vedika Securities.
Anyway, I think in this particular, they have not given any particulars of the, in this written statement, did they give any particulars?
They have given entirety, your lordship. They have disclosed, your lordship, this written statement, by way of this written statement, what actually happened to the shares of Bhagirath Murarka. The reason is very simple, your lordship. Your lordship has to only assess, your lordship, the application filed by them. Because paragraph 8 and 9, your lordship, is the important one. Lordship, kindly take your lordship once and then I'll show the written statement. Because today, before this honorable court, you have to first justify that what happened to the two between the two paragraphs, paragraph 7 and paragraph 8. After 2004, they are saying in 2023, they were shocked to receive the letter from Vedika. Whereas the actual case is they had knowledge of everything. Regarding, your lordship, the wrongful and fraudulent transfer of the shares by the executrix, this is one of the, your lordship, allegations, your lordship, in this application. Somebody, your lordship, with deepest respect, who has drafted it had no knowledge, your lordship, that the suit is pending before the Alipur court. That's why, your lordship, paragraph 7 and 8, your lordship, there is no connection. Paragraph 8, the main cause of action starts at this juncture. Upon receiving a letter on or about 16th of July 2023, the petitioner was shocked to learn that on 10th of July 2023, the statement of holding of late Bhagirath Murarka shows only 3,000 DSK software equity shares in the account of the testator. As such, there were various shares lying in the demat account, and suddenly on this particular date, he came to know that
Anyway,
these
the
shares have been
factual
transferred.
aspect is, you see, there is no explanation for the delay. Factual aspect is, as per the nomination assignment, the shares were transferred to this
mother,
to the wife of the testator. Yes, that is as per
Delay,
the
your
nomination.
lordship, delay, he can explain.
Yes.
That okay, I could not know. After 15 years, I have come to know. That's why I've approached this honorable court. Delay is not important.
So
Here,
what
your
are
lordship, the intention is
no,
important.
what are the subsequent developments for which this application is filed? Okay, because one suit is there. So what are the subsequent developments for which the applicant is compelled to file?
There is no subsequent development. There is only one letter which I have all disclosed. That is page 95 of the application. They are saying that Vedika has given me a statement where I have come to know that only 3,000 equity shares are there. Lordship, kindly appreciate.
This letter was there in the written statement.
Yes, the facts were there. No, this letter has been subsequently given.
No, subsequently given. That means during the pendency of the suit, after they have filed the written statement.
No, Lordship, the information which they have given, your lordship, in the year 2023.
Yes.
Was given, they had knowledge since 2013, at least.
Now the question
2013.
is, save and accept this document, there are no subsequent development. Assuming if it is admitted that this document is the only subsequent development.
Reason is, your lordship, in that particular letter, Vedika has specifically mentioned that in 2018, I have given the entire details to you. But again, I am giving you.
Okay. So that
I am not giving any further details. I am giving the details which were existing at that point of time.
So the subsequent development, that is that during the pendency of the suit, they have received this letter. Save and accept this letter, and they are
nothing. There is no particulars. There is no cause of action for filing.
That is why you say that 7 and 8. So
exactly
what happened these years?
Exactly.
So that is the letter which they have relied upon.
Exactly.
Taking the same letter twice.
May I show this one? Lordship, kindly take page 239. Lordship, that is the written statement filed by the defendant number 9.
That is what? That is Vedika.
Vedika.
Anyway, they have given the particulars, okay, that before the court.
Yes.
Which was within the knowledge of the plaintiff.
Of the plaintiff.
Okay, now the question is, the plaintiff again sought for clarification in 2023.
I'm grateful.
Okay, and thereafter they again gave that clarification.
And they are no. If they're giving the clarification, I can understand. In the meantime, something has happened. They are saying that they have first time they have come to know that, your lordship, the shares have been transferred, and on that basis they allege me.
It's 252.
Page 239. Page 239 is the written statement filed by them. Now, your lordship, kindly take page 240. Why I am saying so? That this letter, your lordship, is nothing but only to file this particular application before this honorable court. Page 240, your lordship, kindly sees paragraph 8.
Yes.
Para 8, without prejudice to the above, but strictly adhering to the aforesaid contention, the answering defendant, the following facts and makes the following submissions are immensely necessary for the proper, effective, and better adjudication of the instant suit. The answering defendant is engaged in the business of stockbroking and depository services. The answering defendant is duly registered under the Security Exchange Board of India as a stockbroker, being the member of National Stock Exchange, and a depository participant, being the business partner with the Central Depository Service Limited and National Security Depository Limited. Now, Your Lordship, kindly take page 241.
Yes.
One Bhagirath Murarka requested and applied and or approached the answering defendant, inter alia requesting to open an individual beneficiary's account with the answering defendant in his name on 27th of June 2000. And at the time of such application, the said Bhagirath Murarka was agreed to be abide by and to be bound by all the rules of the rules as enforced from time to time for such account. Pursuant to such request, the said Bhagirath Murarka, the answering defendants, opened an individual beneficiary account having account number such and such in the name of Sri Bhagirath Murarka, and necessary agreements were made and or executed by and between the said Bhagirath Murarka and the answering defendant on 27th of June 2000. In accordance with the terms with regard to the nomination on beneficiary's account, the nominations can be made only by the individual holding beneficiary owner's account. The said Bhagirath Murarka nominated his son. So therefore, earlier the nomination was done in the name of son, but subsequently due to the strained
minority
relationship, yes, and thereafter it was changed. You should kindly see. The said Bhagirath Murarka nominated his son Praveen Murarka, who is the applicant here.
Thereafter, this Shashi Murarka.
Yes, in respect of the account, but subsequently, the said Bhagirath Murarka has changed such nomination and nominated his wife Shashi Murarka in respect of the account bearing number such and such, and the answering defendants recorded such nomination. The said Bhagirath Murarka died on 5th of September 2002, and by a letter which I have shown, by letter dated 10 September 2002, the said Shashi Murarka, being the nominee of the said account, intimated the answering defendant about the demise of the said Bhagirath Murarka and also requested to transfer the shares lying in the aforesaid depository account of the said Bhagirath Murarka in her name. Pursuant to the request of the said Shashi Murarka, and after completing necessary formalities, the answering defendant transferred all the shares in the name of Shashi Murarka, save and except the shares of one company which were already pledged by the Bhagirath Murarka. This is 3000 DSK shares which has been given in the letter of Vedika Securities at page 95. There is nothing, no new cause of action. Now, after transferring the shares lying in the account, let Bhagirath Murarka in the name of the said Shashi Murarka, being the nominee of Bhagirath Murarka, the answering defendant, is not liable in respect of any kind of transaction, if any, made by Shashi Murarka. By an email dated 17th August 2006, National Securities Exchange Securities Depository Limited intimated the answering defendant that the plaintiff had made a complaint against the answering defendant. In the aforesaid complaint, the plaintiff had complained that in spite of repeated requests and demands made by or on behalf of the plaintiff to provide the statements of transactions regarding the shares lying in the said account, the answering defendant has failed and neglected to do so. Pursuant to such request, the answering defendant duly replied to the same video later dated 28th August 2006, inter alia explaining that the answering defendant had provided the statements to the plaintiff despite the fact that he is neither a nominee nor a joint holder in respect of the above shares lying in the account, and the answering defendant is not liable to provide the same. So therefore, they had knowledge on 26th August 2006 also. Now, kindly take page 244. By a letter dated 31st August 2006, the plaintiff requested and or demanded the answering defendants to provide statement of accounts in respect of the shares lying in the said account. The plaintiff is neither a nominee nor the joint holder of this aforesaid depository account, and as such, the answering defendant is not liable and or bound to provide the statement of transactions regarding the shares lying in the above account to the plaintiff. However, the answering defendant provided the same to the plaintiff. By a letter dated 17th of September 2006, the answering defendant further intimated the National Security Depository Limited that the shares lying in the said account had transferred in the name of Shashi Murarka, being the nominee of Bhagirath Murarka. By another letter dated 29 September 2006, the Security and Exchange Board of India intimated the answering defendant that the plaintiff had made a complaint against the answering defendant. In the aforesaid complaint, the plaintiff had alleged that in spite of repeated request and or demand made by or on behalf of the plaintiff to provide a statement of transactions regarding the shares lying in the account, the answering defendant has failed to and neglected to do the same. Now, kindly, paragraph N. Pursuant to such request, the answering defendant replied to the same interiorly, explaining the answering defendant had provided the statement to the plaintiff, though he is neither the nominee nor the joint holder of the aforesaid, and the defendant is not liable to provide the same. The National Security Depository Limited, with a letter dated 10th of October 2006 and 10th November 2006, instructed the answering defendant either to act as per the instruction of Srimati Shashi Murarka in respect of the securities held in the account bearing number such and such to the court order. After the transferring the shares lying in the account in the name of Shashi Murarka, the Shashi Murarka is entitled to transact those shares, and the answering defendant has no control over such transaction. In spite of the facts as aforesaid, the plaintiff has instituted the suit upon certain surmises and baseless allegations against the answering defendant. So this particular entire fact, they had knowledge when the...
Apart from this account, are there any other shares which there is allegations?
No, Your Lordship.
7x only this account.
Only this account. Only this account, and that is the cause of action in the application also.
Application as suit, there are different allegations probably.
Suit, there are different allegations. That, Your Lordship, the suit court is in session of the matter.
So far this court is concerned,
yes, Your Lordship,
the only main allegation is this, and suppression of material facts for which 340 is filed.
Yes, Your Lordship. Lordship, I need to take another, Your Lordship, because I need to show the judgments. Your Lordship, I understand,
So
Mr.
on the next day you have to conclude.
Mr. Mukherjee and Mr. Your Lordship, both are waiting for their witnesses.
Yes.
And they are looking me.
Please conclude on the next day.
Yes, sir. Any date.
The affiliate in opposition that my learned senior friend is referring to, page numbers are not matching with the received copy from our
What do you want?
application. Also, my learned friend had indicated. Copy
I'll provide you.
Last occasion also this prayer was made, but no copy has come forward. Even
Anyway, you just tell your advocate on record to sit with the other side, advocate on record, and sort out the matter. Yes, record and order. Learned advocates for the parties are present. Learned advocate representing the petitioner executor has submitted with regard to GA3 of 2024 but could not conclude the same. Fix. Fix 21.
the 2021st second half, Mullah will keep it in the first half, not in the second half.
First half, usually the chamber matters. It becomes difficult.
Excuse me for 20.
Okay, 20th on the first half?
20th. 20th.
Yes. 28/2025 for further hearing of the matter. 20/8/2025. না 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 নরমাল এই ফার্স্ট হাফের দিকেই থাকবে No, I'm keeping it in the first half. Okay. আচ্ছা আর্গুমেন্টসটা ডেকে দিন আর্গুমেন্টস
Yes, may I please?
Yes.
Item number 20, my lord of notice,
Okay, just wait. Let the matters be completed. Mention at the time of rising.
I just wanted to indicate, my lord, I think he resigned.
Brief.
Argue my argument.
Brief for it.
There are 3 judgments. I've already forwarded these judgments.
একই ব্যাপার চলে
My lord, he can deal with it while he's arguing. And my lord,
ঠিক আছে বসে যা দাঁড়াস না
or my lord, putting my
No, in your written notes of arguments, you have made the compilations. So, entire thing.
No, written notes you have filed.
No, I'm not filed. I'm prepared.
So I shall record that you are filing it today. Let it be exchanged.
My lord, I can file it today. As and when my learned friend gives his copy, I will exchange with him.
Okay.
No, after he files,
because I have to complete my submission thereafter. We will file it thereafter, because I don't know what he will say in rejoinder.
Then it's better you exchange and then file. Both of you exchange the written notes. Yes, today you want
We can only prepare, your lordship, after he finishes, after the arguments are finished.
No, you make your submission, oral submission today.
Yes.
On the
I will
day.
not finish my oral submission. I will take time. Your lordship will give another date. I will try to sort it up within whatever time possible. Let me start my argument.
Yes.
Your lordship, without opening the briefs, your lordship, let me take your lordship through the brief facts of the case and what is the case of malicious prosecution about. Your lordship, there are the factual situations are not much.
Just wait.
The documents are not much which your lordship have to look into. So, your lordship knows the principles of malicious prosecution. Now, this malicious prosecution is divided in two stages. One is malice. That is ill intention, ill motive. A person doing an act or prosecuting a person with the intention of causing harm and damage to his reputation or to cause any adverse impact to his career or professional status or social status amounts to malice. Prosecution, your lordship, initiation of a litigation against a particular person. Now, if a person with the intention of ill motive causing disrepute and harm either to his personal character or to his professional character initiates a litigation in any court, that amounts to malicious prosecution. Now, here, your lordship, what has happened in the instant case is that your lordship knows that plaintiff was appointed as a distributor of the defendant company, proprietorship concern, for distributing his Ayurvedic products in North Kolkata. Now, the transaction goes like this, your lordship. The plaintiff used to place orders upon the defendant on the basis of the demand of the market. The defendant used to deliver goods to the plaintiff. Plaintiff used to store those goods in their godown in Calcutta and used to sell the goods to various retailers, and all as per the demands raised on behalf of the defendant company. Your lordship, pursuant to that, apropos to this, in respect of two invoices, goods were procured by the plaintiff from the defendant. Now, it was the usual practice that whenever the goods are delivered by the defendant to the plaintiff used to purchase the same and used to give security checks, blank security checks for securing the payment. Now, what was the purpose for giving the security checks? If the plaintiff, after purchasing the goods, fails to pay the money for the goods that they purchased, in that occasion, the defendant, upon prior intimation to the plaintiff, will deposit the checks at the concerned bank so that the payment is liquidated on behalf of the plaintiff. Now, if the payment is earlier made, then there is no question of depositing the checks for liquidation. Now, here what has happened, your lordship, in respect of two invoices, your lordship, of 2003, goods were procured by the plaintiff. Now, for that, blank security checks were given. Now, after procuring the goods, it was found, it has come up in the evidence during the section 138 proceeding. After the goods were procured, your lordship, the plaintiff found that majority of the goods were damaged. So the plaintiff said that whatever checks I have given you, don't deposit those checks for liquidation. I will pay off the money upon a settlement being arrived at. That suppose the bills are of
these facts before the this thing criminal court. This fact.
Yes, I will show the judgment. I will show everything has come out. The judgment is very clear. Now, what has happened? Majority of the goods, payment for majority of the goods were not payable. So we said that don't deposit the checks which I have given
in writing.
Yes. We are trying to settle the matter. There is a process of settlement going on between the parties. Proposal for settlement came from the plaintiff. The defendant also exchanged letters. Thereafter, meetings were held at Peerless. Thereafter,
all these documents were exhibited before the criminal court as well as here. Before this
civil, your lordship, civil court. Those documents are not required to be further exhibited because the judgment of the criminal court has not been challenged, where all these evidences as deposition has transpired. It is there recorded in the judgment itself. I will place the judgment. Without going into the papers, I am giving a brief overview what has happened. We said that don't deposit the checks because since proposal for settlement has been given, the matter is most likely to be settled. This letter, your lordship, will kindly keep a note of the date. 5th August 2003, first letter given that yes, as per the invoices raised, this is the amount. After adjusting, this is the amount which is due of 88,000. don't deposit the checks. Now, what the defendant did, without any prior intimation, the checks were deposited. And obviously, when we came to know that the checks have been deposited since the settlement process was going on, we instructed our banker stop payment. It is the check has not bounced because of insufficiency of funds. That is not the case. It's a case of stop payment. Intention why we stopped with the payment was that since there's a settlement process going on, question of liquidation of the checks does not arise. Thereafter, Your Lordship, letters were exchanged between the parties from time to time. In the meantime, in 2005 or 6, got a summons. 2005, by the end of 2005, I got a summons in respect of a 138 case filed by them before the Delhi court. I'm not on the jurisdiction. They are filed before the right court. Because where the check has bounced, that court will have jurisdiction. I did not get a notice under 130. That was my case before the Rohini court, that I did not get a notice. Summons was issued. I only came to know of this initiation after I received the summons, and thereafter I appeared in 2006. At the beginning of 2006, and took a bail. So that is the date of my knowledge of the initiation of these 138 proceedings against me. Before that, Your Lordship, when the first letter was exchanged on 5th August 2003, thereafter we have issued 2 demand drafts. One in November 2003, another in December 2003. For a sum of rupees 35,000, and some of the defective goods which were lying in our godown, we said that you take back the goods, issue a credit note, that in respect of those goods, money is not payable. So the total amount of settlement, the exact amount by which the dues were settled was 53,000 and odd. This was within their knowledge. They have accepted the demand draft November and December 2003. Now, after I appeared in 2006, I took out the case records. I came to know that this 138 proceedings has been initiated by them sometime on 14th of November 2003. 10th of November 2003. Now, when they initiated this 130 proceeding, that's what I say. Now my first contention arises. This initiation of the 138 proceeding was done with the malicious intent of causing harm, and they had no reasonable and probable cause to initiate this proceeding. Why? Because at that point of time, when they initiated this proceeding, they knew that there was a settlement proposal. Settlement process was going on. Letters have been exchanged way back in August 2003. And we have said that this is the amount which we will pay. So they had no occasion or any reasonable or probable cause to initiate this proceeding under 138, because Your Lordship knows the language of 130 is that when there is a legally enforceable debt, when a legally
the moment you issue a check, it is admissible. It is admitted that there is a check, unless the contrary is proved.
Oh, yes, it is rebuttable under
Anyway,
119.
you see that criminal code.
I'm not going into that.
Criminal court judgment is not challenged, but on what grounds the acquittal was given, that has to be seen.
Settlement.
To find out whether really it was malicious or not.
Yes. The ground on which the acquittal was given was that there was a settlement long back with regard to the dues. So there was no legally enforceable debt as on the date of filing. If there is no legally enforceable date.
No, is it the findings of the court, or is it the court's observation that the plaintiff has failed to prove that there is a date?
No.
If the court finds one thing and the court
finding.
Observe that the plaintiff has failed.
Court has recorded that there is a settlement between the parties with regard to the checks issued. I will show that. I will come to that. I'm not going into the papers right now, because this is the first day I am commencing my argument. Court said that there is a settlement process. Now, my first ground of objection is that when my learned friend knew, the accuser, the complainant knew that the matter has been settled between the parties, or settlement proposal is going on, why did they suppress this fact before the court while filing this 138? With regard to the same transaction, there is no separate transaction between the parties. Secondly, even after initiation, if my learned friend says that this exact money, the money which was settled, was paid after the initiation of the 138 case. 138 case is 10 November 2023, and the demand drafts have been paid on 14 November 2023. Now, if they say that no, money has been paid after initiation, then also the law says that any institution or even continuation of the proceeding with the intention of causing harm also amounts to malicious prosecution. Now, suppose kindly, Your Lordship, visualize an situation. Today, I have a money claim against my learned friend. I file a suit before this court. Now, after filing of the suit, there is a settlement proposal between me and my client. He pays me the entire money in view of the settlement. I suppress that fact before the court and I continue with the proceeding. Even I pursue this court.
Whether that payment is accepted by your learned friend as a full and final
Yes,
settlement.
that has
or
been
not?
accepted.
Why any letter you produce that it is a full and final settlement?
I have given a letter.
Any terms of settlement document or any letter that
Terms
this
of
is
settlement is not required because
no,
they have
whether
not denied this.
whether it is accepted by him or not, that is a question.
Accepted. That's why they have not challenged this and they have not gone up in appeal as well. Settlement process they have accepted. Where?
There is an appeal, although I did not succeed.
I don't know what appeal. I am not aware.
There is an appeal.
Where is the appeal? That has not come up in evidence. We don't know.
There is no evidence on that. But
Then how?
Have you taken that in your written
No,
statement?
not said
It is
anything.
not stated in the written statement. There was an appeal,
These
may have.
Anyway, if it is not there, there
that
is
is
no
not
scope.
there. That is neither here nor there. If it is not pleaded, not produced in evidence, cannot be taken any cognizance of.
It is a part of the list of documents to my written statement. Where I'm saying they're making the statement,
Where?
but
Show
that
me.
document is not there. It is not part of the record. That is also.
Worship, may I just read the averments which they have made in the written statement? They said that
List of documents.
no, defendants have decided not to file an appeal. That is their statement.
No, but taking the list of documents, there is.
The list of documents is contrary to your averment.
I'm just indicating that it was there.
This says that chose not to prefer. I mean, it's neither here nor there is no appeal. So the fact is that there is a settlement has not been denied. That has come up in evidence before the 138 court. It's a judicial order, not challenged.
This suggestion was given that there is a settlement for which your client is not liable. That suggestion was put to the complainant's witness.
Yes, everything. I will. Yes, everything.
And that suggestion was denied. Normally, that suggestion was denied.
Lordship knows the suggestion denied, but your Lordship knows that suggestion in a criminal case is much different to a suggestion in a civil case, because in a criminal case, when a cross-examining counsel put the suggestion, that is not in the pleading. But in a civil case, your Lordship, in a civil suit, normally everything is pleaded. So suggestion normally doesn't make any difference in a civil court. Even in a criminal case, a suggestion was put that there was a settlement. Obviously, I don't know what they have denied or not. But in the judgment, it is recorded settlement have taken place 2003. Okay. And on the basis of that, acquittal was given, not challenged. So my first contention is that, first of all, initiation was bad because in view of the fact that there was settlement. So there was no legally enforceable debt. Legally enforceable debt before a court of law which he will prosecute.
Right.
Second of all, continuation of the proceeding after the settlement has happened. And I have given the money. Suppressing that fact, you are continuing with the proceeding. Rather, in 2005, you pursue the court that summons should have been issued to me. Thereafter, summons issued, I appeared for the first time in 2006. What prevented you after the filing of the 138 case till 2006 to withdraw the case? If your intention was bona fide and honest, you should have gone and said that no settlement has happened. There's no question of proceeding with the suit. Similar situation I gave you, Lordship. Money suit between me and my learned friend, settlement, I suppress that fact and proceed with the suit. So continuation is also malicious. What is malicious? Ill intention, ill motive. I know that what I am doing is wrong, but what I will post this as if it's a correct act. What I am doing is correct. But I know that in my mind that is a wrongful act. So kindly in view of this, your Lordship will kindly take few definitions of malicious prosecution that will help in the adjudication of the case. First is the definition of malicious prosecution as per the Black's Law Dictionary. I'm handing over one copy to my learned friend. Your Lordship will kindly see.
Yes.
Your Lordship will see malicious prosecution, Lordship, on the right-hand portion.
Yes.
The institution of a criminal or civil proceeding for an improper purpose and without probable cause. The tort requires an adversary to prove 4 elements. The initiation or continuation of a lawsuit. So kindly see, the first, your Lordship, the first definition of malicious prosecution is that either initiation or continuation. Both amounts to malicious prosecution. without a reasonable cause. Lack of probable cause. Now, Lordship will see what was the probable cause. Suppose if a check has been bounced, I am under the law, I have a statutory remedy to proceed under 138.
Yes.
If there is a legally enforceable date. Now, at the time of initiation or after the filing, if I am aware of the fact that no, I have entered into a settlement, there is no legally enforceable date to me because he has paid the money as per the settlement. That means there is no probable cause to proceed, to either institute or proceed or to continue. There is no probable or reasonable cause.
All the judgment will speak for itself.
Yes, I will cite judgments to that effect. Now, Lordship, kindly see.
The judgments of the criminal code, that will speak for itself.
Yes, I will
What
cite.
were the materials before the court?
Yes.
And
All the
on what
materials are
basis
there.
the court came to the findings?
Yes. That I will place. But for that, your Lordship has to first appreciate what is a malicious prosecution.
Yes.
There has to be a reasonable cause. I have to have a cause against my learned friend that yes, this check amount is bounced. I have given him a notice for 30 days. He has not paid within that time. So there is a legally enforceable date which I am entitled to recover. So I am filing a case under 138. The ultimate punishment is either you pay back the money with interest or civil imprisonment for 6 months. So there has to be a reasonable cause. Now, even before the filing of the 138, if the matter is settled, or even after filing, then there is no reasonable cause to proceed. Now, second, your Lordship, 3, malice, favorable termination of the lawsuit. So there is a favorable termination of the lawsuit in my case because I have been acquitted from the proceeding. And there is no appeal. They have accepted the order. And 3 is malice, ill intention. So what was the ill intention? That even if I am not liable to pay any money, but I will proceed against you so that I can disrepute you, I can impute your character either by sending you to civil prison or I can extort money from you with interest. That was the malice. Now, Lordship, kindly come to the second definition of the malicious prosecution as per the law lexicon. Okay. Yes.
Yes.
Lordship will see left-hand column. Malicious prosecution is a prosecution on some charge of crime which is willful, wanton or reckless or against the prosecutor's sense of duty and right or for ends of he knows or is bound to know are wrong and against the dictates of the public policy. In malicious prosecution, there are 2 essential elements, namely that no probable cause existed for instituting the prosecution or suit complained of, or that such prosecution or suit terminated in some way favorably to the defendant hearing. So first the court has to see whether there was any cause of action, reasonable or probable cause of action to institute the 138 proceeding or not. And as Black's Law Dictionary also says, whether he had any reasonable and probable cause to continue with such proceeding or not. And second, your Lordship has to see whether that proceedings had terminated in favor of the defendant or not. Here it has been, the judgment is in my favor, so I have been acquitted. The term malice, as used in the expression, malicious prosecution is not to be considered in the sense of spite or hatred against an individual, but of malus animus, and as denoting that party is actuated by improper and indirect motives. Intention also has to be seen into. Then your Lordship will kindly come to the next page, the right-hand column. Malicious prosecution, malice. Malice means an improper or indirect motive other than a desire to vindicate public justice or a private right. It need not necessarily be a feeling of enmity, spite, or ill will. It may be due to a desire to obtain collateral advantage. I say, by citing this definition, that the desire of my learned friend by instituting the 138 proceeding was to extort money. Because once the settlement has taken place, is no question of arising, no question of
That
proceeding.
means for illegal, that means in an unjustified way.
Correct.
Not that, that means first of all, the date has been settled or liquidated.
Correct.
Thereafter, he is extracting money, squeezing money in an illegal way.
Illegal way setting, this is in abuse of process of law, setting the law in a wrong motion to gain unjust enrichment at my cost. So actually, for recovering the debt, he had no reasonable cause because the money has been paid by that time. 138. Now, Lordship will kindly take the definition of section 138 once, if your Lordship has the NI.
You see, we have to go by the judgment. Okay.
Yes, yes.
What are the observations made in the judgment? What were the evidences that you
No,
said?
before the observation, Lordship, the law
Thereafter,
also
the
has
court can come to
Correct,
the
I will-
conclusion whether it was a malicious prosecution or not.
Yes, yes, absolutely. But three things are admitted, your Lordship. Payment of settlement amount, there is no denial. Because on the basis of that acquittal given, that has not been denied by them anywhere. Either if
See,
they were
merely acquittal, you see, on
Your Lordship, this is
on
not
the
a mere acquittal.
mere acquittal is one thing, and holding that the complaint is a frivolous or a misconceived, that is
Not
another
to
thing.
be held, your Lordship. If I can show, even the continuation was incorrect because the checks on the basis of which he was proceeding in a 138 case, in respect of those checks, there was no legally enforceable date as on that date. Because they have received the money in view
Because
of
you see,
settlement.
we have to confine ourselves within the judgment. Okay.
Not only the
And-
judgment, the
And
evidence.
what was the complaint made before the authority? These are exhibited. The complaint made.
What they have done, because they have produced the certified copy of the proceeding before the court below.
Okay.
I will show from those documents.
Yes, very well. Now,
Lordship will kindly come to the definition of 138. Lordship has the NI Act.
anyway, you place it. It is
Yes.
not necessary. You see, whether 138 ingredients were complied or not, this
No, it's not about compliance.
This court will not sit in appeal over the judgment of the complaint. The court has to see the
I know, Your
evidences, the observation made by the learned judge, and thereafter the court can come to the conclusion whether it was.
I am not calling upon this court to
because
sit in
this
appeal.
court has cannot review or appeal, sit in appeal.
I don't
for
want the review. I am saying that that judgment helps me. I am placing my
yes,
case
that
on
you
the
have to
basis of
establish.
judgment. I am only citing that what is the purpose of 138. The language is, your Lordship, where any check drawn by a person on account maintained by him with a banker for payment of any amount of money to another person from out of that account for discharge in whole or in part of any debt or other liabilities returned by the bank unpaid, either because of the amount of money standing to the credit of the account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account by an agreement made by the bank, such person shall be deemed to have committed an offence and shall without prejudice to the provisions of Act be punished with imprisonment for a term which may extend to 2 years. So I said 6 months, it is 2 years. Or with fine which may extend to twice the amount of the check. So for the check has to be issued in discharge of a liability. I am saying so the reasonable and probable cause for the complainant to initiate a proceeding under 130 that there was a check issued for discharge of liability that you have failed to pay. There has to be a legally enforceable debt in respect of which the check has been issued. I am showing that as on the date of filing, even thereafter, there was no legally enforceable debt because in respect of those checks, settlement has been arrived at. You have received the money. In spite of that, you proceeded with the complaint and kept it pending for 12 years. After 12 years, I got the judgment of acquittal. So I had to face the ordeal of going to Delhi with the advocates in Calcutta. Your Lordship knows that advocates in Delhi are much costlier. So I had to accompany, I have to engage lawyers from Calcutta. I have to accompany, they have to go to Delhi each and every occasion. Thereafter, I got the judgment of acquittal. So this is the ordeal which I had to face. If you have brought this settlement before the court on the first date instance or thereafter, then this 12 years would not have been wasted.
Okay, continue on the next day.
The Lordship has a matter fixed for.
Yes, record and order. Learned advocates for the parties are present. Learned advocate for the plaintiff submits but could not conclude the submissions.
Could not.
This matter appear on 25/8/2025.
Next.
25/8.
Lordship, 25 and 26, I am not there, your Lordship, any other date.
আচ্ছা 21 তারিখে দেখুন তো কিছু আছে কিনা 21 তারিখে 3টের সময়
21st.
Yes.
Can it be on 28th, your Lordship?
Let it be earlier, otherwise it will be difficult to, you see, conclude. 21st, you have any difficulty?
21st, yes, your Lordship, I have.
আচ্ছা 28 করে দিন 28/8/2025.
So your Lordship is keeping
28. 28. 28/8/2025 at 2 p.m.
Shall I find my notes or shall I find it later on the next?
You exchange the notes. Yes, written notes of arguments be exchanged in the meantime.
Lordship, can it be on 29th instead of 28th?
29th is a Friday. Friday, usually this matters, appellate side matters are taken up. So try on 28th.
First, your Lordship, first then.
Yes?
First, your Lordship, because 28th I will be returning from Delhi, so your Lordship, I don't know whether I will be able, if there is.
দেখুন তো 1 তারিখে ইয়ে আছে কিনা 1 তারিখে
First.
ফিক্সড আছে কিনা এক তারিখে 2 p.m. আছে 4 p.m. আছে ওকে 1/9/2025 at 2 p.m.
Great.
থাক একটা আছে যখন আরেকটা থাক 25 তারিখ এই 28 তারিখে এটা 1 তারিখ yes 1/9/2025 at 2 p.m.
Grateful, Monday. Great.
ওই কে 2 p.m. হ্যাঁ করে দিন হ্যাঁ 3 p.m. fixed matter. Oh, 2 p.m. witness action.
Yes.
Okay, let this matter be taken up 3 p.m.
Yes, my lord, I beg to appear on behalf of the the receiver.
I appear for the applicant.
In the last occasion, my lordship was directed to hail the meeting and accordingly, my lord, this was held. May be permitted to.
You have circulated the copies.
I will circulate.
আপনার সাথে যুক্ত ফুল কষ্ট
Yes, you are for the plaintiff.
Yeah, I'm for the plaintiff.
So regarding this proposed, this intending.
I have already submitted. The only solution would be if in public auction amongst in open court between the interested parties. At present, there are 3 offers have come. So amongst them, if any auction is taken place, that will bring the highest offer.
Before all this starts, my lord, I believe there is a difference of the report which
No,
has
no,
been
there is no
circulated.
difference. This is this one.
Kindly see the report, my lord.
Yeah, I want
One-
the report.
My learned senior is referring to has, my lord, reference of 70 lakhs and everything, but the one which has been
Para
handed-
3 of page 2.
Para 3 of the page.
Yes, my lord, kindly see the one which I have been handed over. There is no such reference.
No, you see, page 2, para 3.
Kindly sees, my lord, the report.
There's some other report given to my lord and some other report given to me. Kindly see the reports.
কোনটা বলছি? Is it somehow mismatching, Millet? I have not checked up, Millet.
Anyway, page may not be telling, but the contents are telling.
Contents are there,
Contents, your
Millet.
lordship, kindly see, I just saw rupees 70 lakhs mentioned in his report.
Where?
I don't find that in this.
Just a minute, you see.
And his reference.
In the two meeting. No, 80 lakhs. Para 4.
Your lordship, may kindly see paragraph 7. Your lordship,
Yes.
see?
Para 4, it is 80 lakhs is there.
My lord, may kindly sees the report which has been handed over to my lord. Kindly sees paragraph 7. There is a reference of 70 lakhs?
Paragraph 7, that is the last paragraph.
No,
That
is
is
the last paragraph. In this report, it continues.
yes. Is it telling with your report?
May I take back, Millet? May I just check? And
Okay, you please come ready with the, you sit
Yes,
with the
I-
parties, come with
there is some,
instructions.
yes, I
Yes,
think-
let this matter. Learned advocates for the parties are present. Special officer, learned receiver files the report. Parties are requested to come with necessary instructions on the report.
Lord, not served yet. How do I come with the instructions?
You sit with him and sort it out, verify.
It's different. How do I come up with the settlement?
No.
If there is a difference of the Millet, the
Okay, whatever
offer,
you have given before this court, let a Xerox copy be
I will
given.
be given, definitely. 70 or 80, how does it matter? If the person,
No, I'm not on.
Let this matter appear on 22, appear on 22/8/2025. Acha, 22/8 na, 29/8/2025.
My lord, fixing any time.
No, in the morning it will be taken up.
very well.
Very well. You shall address on that.
Huh? No, it thak recorded thak. You give them a Xerox copy, what you have submitted.
Xerox Millet in that event, I will, whatever is there, Millet.
Acha, learned receiver is requested to take back the copy of the report, get it Xeroxed and serve it upon the parties.
29. Great.
About 2 p.m.
एक ही
2 p.m. 2 p.m.
एक ही से
No, don't file anything. Come on the next day.
Okay. When is the next date, Your Honor?
29.
Item number 31.
My witness was on the.
এরকম রেড কালারের জামা পরে আসবেন না, ফর্মাল পরে আসবেন হালকা কালারের। অ্যাডভোকেট হয়তো বলতে ভুলে গেছে, প্লিজ মেনটেন করবেন এটা।
Hello, I appear for the plaintiff. May I be permitted to stay online?
Yes.
What is your name, sir?
চিরঞ্জিত মিশ্র।
চিরঞ্জিত মিশ্র। না না, আগে হয়েছে, আগে কি Yes. Yes, sir.
Mr. Mishra, I'm handing over you a bunch of
স্যার
documents.
শোনা যাচ্ছে না কিছু।
Mr. Mishra, I'm handing over to you a bunch of documents which are referred to as DD 41 in the judge's brief of documents. Kindly tell this honorable court what these documents are.
Notarized true copy of pay slips. There are several pay slips deposited to account 7831 31 dated 17th October 1995 for an amount of 1,25,000. Next one, same savings account 7831 dated 27th of October 1995 for an amount 5 lakh. Deposited to account 7831
Go slow, sir.
6th of September 1996 for an amount rupees 2 lakh. Deposited to account 7831 dated 6th November 1996 for an amount 58,333 rupees 33 paisa. Deposited to savings account 7831 dated 28th of July 1997 for an amount of 4 lakh. Deposited to savings account 7831 dated 31 30th of July 1997 for an amount of rupees 1 lakh. Deposited to 7831 dated 25th of August 1997 for an amount of rupees 1 lakh. Deposited to savings account 7831 dated 10th of July 1996 for 20,000. Deposited to 7831 dated 17th May 1996 for an amount of 50,000. Deposited to savings account 7831 dated 21st of September 1996 for 50,000. Deposited to 7831 dated 17th of October 1995 for 100. Deposited to 7831 7th June 1996 for an amount 1,250. Deposit slip favoring Hyman Stockbrokers Limited. Hyman Stockbrokers Limited dated 12th of June 1995 for an demand draft amount of 5 lakh.
1 second. Yes, for an amount of rupees.
5 lakh.
For an amount of rupees 5 lakhs. Excuse me.
Favoring Simon Stockbrokers Limited dated 12th June 1995 for a draft amount of 25 lakhs. Favoring Simon Stockbrokers Limited, dated 12 June 1995, for a draft amount of 10 lakh. Again, favoring Simon Stockbrokers Limited, 12th of June 1995, for a draft amount of 20 lakh.
But so far, DD 42 and 43 are concerned. They are already a part of DD 41. So I'm not tendering them separately, man.
Okay.
They're already a part of DD 41.
Yes, these documents be marked exhibits.
Exhibit collectively as
Collectively.
DD 41. Exhibit কত? না আগের দিন কত হয়েছিল? 39 লাস্ট আগের দিন 38 অবধি হয়েছিল 39 হবে। 38 অবধি হয়েছিল 39 collectively। হ্যাঁ 39 collectively। বলবো? Ready? Yes, sir. Mr. Mishra, I'm handing over to you a document which is a part of DD, my lord, in the judge's brief, my lord, it is DD 44 wrongly, it should be DD 42, my lord. Since DD 40,
whatever is there, you
yes, my lord, it's wrongly mentioned as 44.
So then again, by an order, it has to be altered.
Yes, possibly, my lord. This will be DD 42 because 42 and 43 is already a part of 41.
Okay.
Or the exhibits, my lord, I can place it as 44. The exhibit can be
Yes,
marked
yes,
serial.
yes. That can be altered.
Mr. Mishra, I'm handing over to you a document which is a part of the series of documents of DD 44 in the judge's brief of document. Kindly tell this honorable court what this is about.
It's a memo number 1244, dated 25th of April 2000, from the Detective Department of Lal Bazar, Deputy Police Commissioner, to General Manager and Disciplinary Authority of Bank of Baroda. Regarding communication of prosecution of Mr. Samar Kumar Chakraborty. The Samar Kumar Chakraborty, the then senior manager of Bank of Baroda, posted at Bremen Road branch.
Brabant Road branch.
Bremen Road branch.
Well, may this be marked as an exhibit?
Yes.
Exhibit 40, my lord.
Mr. Mishra,
One second, sir.
I'm handing over to you a document which is also a part of DD 44 in the judge's brief of document. Can you tell this honorable court what this is about? DD 44, part of DD 44.
It's a communication confidential letter
Communication confidential letter
from the Institute of Chartered Accountants of India, ICAI, to the Deputy General Manager, Bank of Baroda, in the matter of complaint against Sri Basav Kumar Sarkar. Matter of complaint against Sri Basav Kumar Sarkar, Chartered Accountant. dated 4th of June 2004.
The document is dated.
What may this be marked as an exhibit?
Yes.
Exhibit 41, my lord.
But that's the document standard. But it's complete. But my learned friend can start the cross-examination today.
My lord, may I be permitted, my lord? I will be starting cross-examination. May I be permitted to do it on the next day?
Yes, yes. Just put one question and let it be.
I can, my lord, put, my lord, a few
Junior
questions.
question and
Yes.
it will be deferred.
Mr. Mishra, do you have any personal knowledge?
Yes, cross-examination of PW.
My lord, DW3.
Is
DW3.
DW3? Okay. Cross-examination of DW3. Yes, put the question.
Mr. Mishra, do you have any personal knowledge about the facts of the case?
No, I don't have, because I was not there at that time, since it is 1995 case.
No.
It's a case of 1995. I don't have any personal knowledge on this case.
Okay. Yes, record an order. Learned advocates for the parties are present. Examination in chief of DW3 is over. Although DW3 is cross-examined in part, but the cross-examination could not be concluded. Thus, this matter stands adjourned till 3/9/2000.
My lord, on 3rd and 4th, we have difficulty, my lord.
এই 4 তারিখ দেখুন তো কোনো ই আছে কিনা।
My lord, 3rd and 4th, we have some difficulty, my lord.
আচ্ছা, 8 তারিখে 8 তারিখে
after 9th month.
Beginning of the week.
আচ্ছা 10/9/2025 at 2 p.m.
Might will kindly
2025, my lord.
Yes.
In the beginning of September, my lord, because the difficulty is, my lord, the witness, my lord, now has been transferred to the northeast, but he has to come down on a regular basis. Then.
So that is 10/9 I'm keeping it.
Yes, 10/9 is
10/9. Sufficient time is getting.
My lord, may a time be fixed, my lord?
Where
Yes,
time
2 p.m.
2 p.m. Grateful.
Grateful, Lord.
Thank you.
এবার কি এবার
My lord, item,
ডেকে দিন। Yes.
my lord, before
Item
the
number 30.
3 p.m. matter.
oh, before that is taken up, my lord, item number 14 of your lordship's list, which was fixed at 4 o'clock.
Yes.
Lordship,
Last
we were
order
supposed
which
to
was
give a
passed.
supplementary affidavit in this matter.
That
Let
is
me
not
take up 3 p.m. matter. Thereafter, I shall come to 4 p.m.
But I just need time to file my supplementary affidavit.
Okay. That is
Item number 14, Lordship.
Item
okay.
number 14.
Item number 14.
My lord will kindly record my objection, but I understand, as I understand, kindly make it peremptory.
Okay. Learned
because the
advocates
order
for the parties
It's one
present
once we are
on
taking
the
exception to the report of
on
the
the prayer of
verification report, Lordship.
just a minute. Item 14. Learned advocates for the parties are present on the prayer of learned advocate appearing for
Plaintiff's Lordship.
plaintiff. The time to file supplementary affidavit.
Not
stands-
supplementary affidavit, your lordship, supplementary exception to the clarification.
Okay. Supplementary exception to the report.
Clarificatory report of the valuer.
Supplementary exception to the valuation report.
To the
Clarificatory
report.
Okay. Supplementary on the prayer of learned advocate for the plaintiff, time to file supplementary affidavit to the clarificatory report of the valuer stands extended till 10/9/2025.
My lord, peremptorily.
No
and an
further
advance
adjournment
copy-
will be granted without costs.
Yes,
on
and
the next day.
Lordship, it's just one day.
an advance copy will be served also.
No further adjournment will be granted on the next day.
Yes, and an advance copy of the same may be served on the
That
defendant.
will do, Lordship. That will do.
Grateful to lordship.
This is a 14.
Grateful to
Item number 30.
I am for the defendant. I would be cross-examining the plaintiff's witness.
My examination is over, my lord. I think one question was put by my learned friend.
Today is for cross-examination of PW1.
Yes.
Is your name, sir?
Praveen K. Popat.
Kindly write it down. Madam. বললেন উনি
কি মানে ক্রস নাকি ক্রস এক্সামিনেশন পুরনো ডেপোজিশন আপনাদের আছে তখন 13 May 2025 এর লাস্ট রিচ
2025 excuse me
2025 cross examination question 84 correct
Yes, please.
84 অবধি হয়েছিল 85 থেকে may I start with my lord's case leave on the last occasion you had deposed that the defendant had paid an amount of rupees 9365 which included rent, property tax and a part of commercial surcharge on property tax. Would I be correct if I say that the actual rent amount was rupees 8070?
Yes, the rent only was 8070.
Did the defendant make payment? Did the defendant ever make payment of any rent above the said amount?
Yes, he made payments of the rent plus the property tax and the commercial surcharge.
Question repeated. Question repeated.
Make payment on any
Of any rent.
above the said amount. Yes.
I'm only on the rent.
Only the rent. No.
No.
Answer to no.
No.
So the last agreed rent between the parties was rupees 8070. Am I correct?
Yes, the rent only was 8070.
Please have a look at paragraph 8 of the plaint. To paragraph 8 the plaintiff.
প্লেনটা দাও
Who
প্যারাগ্রাফ 8 থেকে পরের পাতাতে আছে
Who are these entities mentioned in this paragraph? Paragraph 8 goes on to the next page.
The question is, who are the entities mentioned in the paragraph, said paragraph?
Yes, the entities are set out in this paragraph. First one is Nirmaya Investment and Dealers Limited.
No.
Nirmaya.
No, the name is there. I mean,
Yes.
who are these entities? How are they related? That is my question.
That question.
According to the plaintiff, these entities are third parties.
These entities are the third parties.
Would I be correct if I say that these entities are the group companies of the defendant?
The plaintiff is not aware of this.
did the agreement between the parties mention that the suit property may be used by the group companies of the defendant as well?
There was such a clause.
Companies
as well. Yes, sir.
Group companies of the
There
defendant
was
as
such
well.
a clause.
There was such a clause.
There was such a clause.
I suggest to you that the entities mentioned in paragraph 8 of the plaint are the group companies of the defendant.
First say you agree or disagree, then give your answer.
I do not agree.
I disagree.
According to you, is the defendant at present occupying any portion in the suit property?
Defendant is occupying 8,070 square feet in the 8th floor of the suit property.
8,070 square feet.
8070.
By defendant, do you mean Kamarhatti, Kamarhatty, Company Limited, or its sister concerns, or its group companies?
No, Kamarhatti Company Limited.
Did the plaintiff ever take any step to have the rent enhanced from rupees 8070 per month by filing any application before the rent controller, Kolkata?
The rent controller was not there at that point of time.
I suggest to you that the notice to quit is bad in law.
I do not agree.
Yes. Lawyer কি আর বলবে, but আমাকে বলতে হবে। I suggest to you that the letter by which the plaintiff had claimed enhancement of rent and imposition of maintenance charges, sorry, rent, enhancement of rent and imposition of maintenance charges was unilateral, and there was no consensus ad idem between the parties for any amount of rent in excess of rupees 8070 per month.
Yes. Have you understood the question?
Yes, my lord. The claim was made in accordance with law.
Question repeated.
I suggest to you that the letter by which the plaintiff had claimed enhancement of rent and impositions of maintenance charges, they are unilateral, and there was
No, excellent. Imposition of maintenance charges was unilateral.
there was no
Consensus ad idem
between the parties for any amount of rent in excess of rupees 8070 per month.
The claim was in accordance with law.
No, my question is, was it? Very well. I put it to you that the tenancy between the parties is governed by West Bengal Premises Tenancy Act and not the Transfer of Property Act.
I do not agree.
Will you kindly give me a minute? Well, those are my questions.
Concluded?
Yes.
Yes, record and order.
Please step down and stay here.
Learned advocates for the parties are present. PW1 is examined, cross-examined and discharged. Documents filed be marked exhibits.
Just 1 minute.
So further evidence of PW?
No, no further evidence.
Evidence of PW will be complete. You will be treated to be complete. Learned advocate submits that the plaintiff will not examine any other witnesses. Thus, 3/9/2025.
Sir, one question in re-examination, if I may ask. Just one question.
So then again you have to that the scope is limited. You come with a petition. Why you want to re-examine the scope?
No. Here and now only I would. Just to clarify, no application.
Yes. Are you agreeable to re-examination?
One question.
Okay. Then let it be re-examined.
One question.
Yes. Okay. PW1 in recall.
In re-examination.
Re-examination on recall.
Did the rent component? Oh, sorry.
No, re-examination.
Re-examination. Did the rent component include maintenance and property tax, including surcharge?
The maintenance was not paid by the defendant.
Was the rent component
Answer to that. The
Rent.
maintenance was not paid.
rent was the rent component, apart from the basic rent, include the maintenance and surcharge?
Yes, the maintenance was payable, property tax was payable, and the surcharge was payable.
Answer to payable.
Yes. Property tax was payable and the surcharge was payable.
Yes. अच्छा order take to लिखे नहीं.
You can step down and stay here.
Learned advocates for the parties are present. PW1 is examined in chief, cross-examined, and further re-examined and discharged. Documents which are already filed be marked exhibits. Learned advocate for the plaintiff submits that no further witness will be examined by the plaintiff. Thus, 3/9/2025 be fixed as evidence of DW.
On the 2nd of September, my lord.
Third.
But could it be
Second, you want fixed 2/9/2025 for evidence of DW. এই 2 তারিখে দেখুন তো 3টের সময় আছে কিনা, দুটো কি 3টের সময় ফিক্স আছে কিনা? হ্যাঁ আচ্ছা 2/9/2025 at 3 p.m.
Great.
May I mention, item number 20?
Item 20.
Yes, item number 20. This is the matter your lordship has heard on the previous occasion. My learned junior had pointed out.
Regarding what?
But this suit has already been disposed of. Suit has been decreed.
Okay, item 20.
Yes, my lord, I think it was shown to your lordship on the last occasion.
So why it is appearing?
I do not know, my lord. They are. I find.
Okay, record and order. Item 20.
Well, your lordship will see on
It is submitted by the learned counsels that the suit is already disposed. Let this suit go out of the list.
Can kindly record the date of the decree also.
No, I've just recorded your submissions.
But otherwise they will come running, because this matter has been going on for 2 or 3 days. We have pointed out.
No, I've just recorded that the suit is disposed. Let it go out of the list.
Very well. But after substitution application, I was told by your lordship's officer.
Yes.
That in the morning when the matter was called on, they have moved a substitution application. I do not know how can it be filed.
GA 29.
That is what is the. I do not know, but because your lordship's last day's order.
GA 29 এই 14 ইয়েতে 20 নম্বর আইটেমে কি কোনো অর্ডার পাস হয়েছে? হ্যাঁ? Oh, it's better. Okay, it's better you see what order is, huh? না GA 20 তে 20
Item number 20.
Oh, most probably I passed an order. You better see what order I
If your
passed.
lordship signs the order, then your lordship will say file a recalling application.
Whatever it is. If
I
even,
cannot file a recalling application because the suit is decreed.
so that means if an order is passed wrongly, it has to be recalled.
No, but then that is why I am mentioning now. Your lordship will kindly keep it, if necessary, to be mentioned tomorrow. Otherwise, my lord, this will be a complete a complex situation will arise.
Order pass হয়েছে।
কাইন্ডলি আগের দিনের অর্ডারটা দেখান না, সেখানে তো লেখাই আছে এগুলো। অর্ডারের ডেটটা বলো। Kindly see the order of last day. Because my junior has been appearing in this matter every day, my lord. It has been said that this suit has been.
It's better you do one thing.
But 7th July, kindly have a look at the order.
I'm keeping it as to be mentioned
Yes.
next week. You better serve a notice upon the applicant's advocate. Okay, and
kindly do not sign any order, my lord.
Yes.
Then let it appear as to be mentioned tomorrow itself. Orderটা দেখান 7th of July. Kindly see my junior's submission is also recorded. Paragraph 2. On the prayer of the learned advocate for the plaintiff, time is granted to obtain necessary instructions at the present stage.
So GA 229 of 2025 is meaningless.
Exactly.
Acha. Let this matter appear as to be mentioned.
Yes.
ওটাকে আগের পোরশনটা তাহলে দেবেন না। Let this matter appear as to be mentioned on.
Let it appear
18 28/2025. Learned advocate is requested to serve notice upon the learned advocate for the applicant in GA 29 of 2025.
Then well, kindly also note, my lord, that no GA 20 will not be considered now. Because
না তাহলে ওইটা লিখবেন, ঠিক আছে? Learned advocate submit that this, because you see you are making submission after the order is passed.
No, your lordship has not signed the order. That is why I am coming on mentioning now.
তাহলে ওইটা কি করে দিন? Learned advocate submit that the suit is already disposed of. The order which is passed in the morning be recalled.
Yes.
Thus, Mr. Sen is requested to serve notice upon learned advocate for the applicant.
I do not know who is the applicant.
You see the record, you see in the GA 29 of 2025. Yes, this is GA 29.
I have not been served with any copy
2025. Let this matter appear on 20th of August 2025.
As to be mentioned.
As to be mentioned.
Obligement.
4 p.m. fix. Yes, 4 p.m. this matter was.
Yes,
কখন কোনটা 4 p.m. আছে? Item
G20.
Item 6-7. Yes, so in these two matters, it may be taken up in the common form and orders may be passed. Okay. It's better you come with a list of dates.
Yes.
With regard to these two matters.
Non-contentious cause.
Non-contentious. Item number 6 and 7. Let this matters appear on 19/9/2025, 19/8/2025, under the heading for orders at 4 p.m. So it's better you come with a list of dates in both the two matters.
Yes.
And with the relevant orders. Because in some cases it is found that it was the caveat is discharged. In some cases it is found that the order recalled. So many orders are passed. You come with a list of dates. In one is probably a letters of administration.
Yes, the executor passed away. So his wife got substituted and then.
And thereafter these matters may be considered. This PLA 112 and all this.
A single order may be passed.
Anyway, let me take up this.
I have to indicate the dates. Yes.
You come with a list of dates on 6 and 7.
Or she can, I mean, if can be indicated that issue of bringing it, otherwise it is coming under the head for evidence. So that
no, I'm keeping it for orders. These two, item 6 and 7. Let this remain in the list. I shall consider afterwards the others.
The others are coming again tomorrow. Lordship had made not today in the first half.
আচ্ছা তাহলে এটাকে ইয়ে করে দিন তো, এই আইটেম 32 to 35 not this week,
Or below on 19th.
just not this week. হ্যাঁ আচ্ছা তাহলে 32 and 30 মানে 32 and 39 let this, আচ্ছা 32 থেকে 35 অবধি, হ্যাঁ 32 থেকে 35 অবধি let this matter appear on 19/9/2025, 19/8/2025 under the same heading.
Yes. Great.